everybody. Welcome to Truth and Transparency. Got a special guest. We're celebrating our birthdays. I'm celebrating mine for like the 10th time. But tonight's special guest, these are the rules. We're going to do 3 cases, 30 minutes each, with a 10-minute at the end highlighting different questions. I'm going to also let Bella pop in, and if she has some questions that she wants to throw Andrea's way. We have a special guest, a criminal defense attorney who I got to meet, and it was a pleasure to meet her and lawyer Lee at the Delphi case. It sucked that it was under such conditions, that's not fun, but totally, like I said, respect both of these people. Lawyer Lee is not here, but Andrea. So we're doing 3 cases, 30 minutes each. We're going to start with, in this order, Delphi, and it's really kind of structured here. Delphi, Idaho 4, and then we're going to end on Karen Reed. Karen Reed, I feel, is like a soap opera, okay? I have a lot of questions ready. Let's bring on, but first, Andrea needs to see this intro. She deserves to see the intro. So we are going to give her a little taste of Truth and Transparency. This was this video was made 2 years ago. Yeah, January, I believe.
Moscow, Idaho, the University of Idaho. Student murders. November 13, 2022. 1122 King Road, Moscow, Idaho. A 4-door sedan was seen in the immediate area of the crime scene, arriving at 4:04 a.m. and seen leaving at 4:20 a.m. This camera footage was given to an FBI forensic examiner with 35 years experience, 12 of those with the FBI. This FBI agent has specific training to include identifying unique characteristics of vehicles, and he uses a database that gives visual clues of vehicles across states to identify differences between vehicles. The neighborhood of the King Road crime scene had numerous cameras, of which was turned over to this FBI agent. From that footage, he initially believed that the suspect vehicle 1 was a 2011 to 2013 Hyundai Elantra, a white Hyundai Elantra. The date on when these video clips were given to FBI is unknown, but we do know that on December 7, 2022, Moscow police issued a press release looking for a 2011-2013 white Elantra and used a stock image photo of a white Elantra in the press release. Logic would tell us that up and until December 7, 2022, there were never any issues or discrepancies surrounding the description of the vehicle seen in the immediate area of the crime scene around the time of the murders. The same FBI agent who examined the footage surrounding King Road used that same footage again to further review that footage, and during that further look said that now it could actually be a 2011 to 2016 white Elantra. Again, the dates of all of these reports will be very important in trial, but they are unknown today. Because it is a fact that December 7, 2022 was the date that the public was told by police to help them locate a stock image of the white 2011-2013 Elantra that was seen in the immediate area of the crime scene. And at no point was it ever modified to include 2014, 15, and 16. So let's take a look at a 2011, 12, 13, 14, 15, and 16 Elantra.
Welcome, Andrea.
Thank you.
Hey, yes, we wanted you to kick it off. Heard a little bit of the Kohlberger 2011-2013 presser. We'll get into that in the middle. But first of all,
throwback to when the case was so simple, right?
Right. So thank you for joining. I appreciate you being here.
Yeah, my pleasure. Well, it was awesome to meet you over there in Delphi. We were very much compatriots in the trenches out there with that whole struggle trying to get into the courtroom and dealing with line jumpers and all that stuff. So Yeah.
right, the line jumper. Almost forgot about her. Can't forget about her.
I haven't.
So, okay, in all the cases that you've ever done, we're gonna start with Delphi anyways. Have you ever seen anything like that?
No.
Never, right?
No.
Okay.
No, just in so many respects, the chaos around it, the lack of transparency around it, the judicial aspect. I mean, never seen a judge like that in my entire life. Yeah.
Do you think that she put on like a facade for the jurors then? Like if the jurors are thinking that, she was, we liked her.
Well, I think that's normal. It's part of the just relationship between them. Judges are always going to be very deferential and respectful to the jurors. She really was, when we saw them, the way she treats the jurors is just absolutely night and day from how she treats the defense lawyers. And it's just it's kind of natural in the fact that they take their instructions from her. She's the only one that can communicate with them throughout the course of the trial. So jurors almost always look up to the judge. Like that's one of the challenges that you have to deal with as the defense lawyer when the judge has a chip on their shoulder against you and is letting that show. Because the jurors are likely to trust that and to think, well, we identify with the judge. And so if the judge has a problem with you, we probably have a problem with you too.
Okay. Yeah. I mean, that makes sense. Like she's so I guess like me saying like she was selling it, it's more like they sell it every day then. That's their job. Okay.
Yeah. It's just normal. It's just normal. I mean, you kind of expect that.
It is what it is.
Yeah.
Here we go. So this is want to just show you guys. Yep, right there. Woo! Give her. She gets a bell.
Love me some cowbell.
Right. Come on now. Let's see. Here we go. Delphi case. These are the topics. Oh, we gotta go this order though. We're gonna start with A. Ready? It kind of come back to the last question, which is, did the jury get it right? Without saying too much, like obviously you don't want to like pound on jurors.
Oh, of course.
What do you think?
I thought there was more than enough reasonable doubt. I would, all I can really say is I would not have convicted him based on, what I saw in that courtroom. I did not see a good case that he was bridge guy. That's before you even get to the whole problems with, is bridge guy even the guy? But even if we go ahead and grant that, they didn't do a good job of establishing that he was bridge guy. Their own explanation, the state's theory of how the murders occurred and the timeline and so forth, it didn't add up with so much of the other forensic evidence, particularly like the cell phone and the health data and things like that. Of course, there was that testimony that we got from the defense at the end that was like kind of a bombshell. First new thing we'd heard, that wired headphones had been plugged into Libby's phone at 5:30 something in the evening and then unplugged at 10:30 at night. So no, I did not think at all that the prosecution had made an adequate showing that Richard Allen was the guy.
100. I thought it was curtains. I was there the day listening to Eldridge testify, which we're going to get into. And when I heard that, I was like, it's over. That's your reasonable doubt if you know what that word means.
Yeah.
Do you think there would ever come a time that on a ticket for the jurors when they're back and deliberating, do you think that it struggles with people to say, hey, I just have a problem saying not guilty versus checking a box that says reasonable doubt, which then like obviously leads to like the acquittal? Do you think that'll ever come a time that's like a mental like struggle for people when they say guilty, or not guilty when they're looking at the tickets? Or
no, you know what? I actually think that's a really brilliant idea to just have the box be reasonable doubt instead of not guilty, or instead of, because yes, I think the whole problem is that people get caught up in the idea that acquitting somebody is equivalent to saying that they're innocent. It's equivalent to like pinning a medal on them and saying, everything is fine and good. And it's not. It's that we're not satisfied that even if this is an awful person, and even if we think, there's some suspicious stuff here, it's not enough to convince us that he did this actual thing he's being charged with. And so courts routinely go through processes of looking at what their instructions are, what their verdict forms are, and things like that. There's always a lot of discussion in academia about what's going to be the best way to do this that isn't suggestive, and that gives a realistic prospect of getting the best best outcome, the best verdict that most accurately reflects the law and what the jury is thinking. The jury are lay people, and so even though they get this long, sometimes over long instruction on all the legal details and stuff, they don't have a lot of time to process it, and they're very new at it, so the more kind of user friendly you can make that whole process, the better result you would expect to get. So I love your idea, and if I ever get a chance to be on a committee for revising the forum verdict or something like that, I'm going to probably pitch that one.
Okay, sweet. Yeah, I love how you say it's lay people, I think people struggle with them saying, well, no, I don't think that they're innocent, but wait, this isn't, I don't know. I'm an I don't knower. So what do I do if I don't know? There's not, they didn't meet their burden. So
well,
and part
of that is how the binary gets defined, right? Because we present it as this binary choice. You check this box or you check this box. And the binary choice in most people's minds is between guilty and innocent. Did he do it? Did he not do it? And that's a logical way to think about it, but that's not the way that the law sets up that binary. It sets it up as the state proved it or the state did not prove it. And so being able to communicate that in a way that that folks could relate to could potentially be really helpful, and maybe make deliberations a little bit easier as well.
Yeah, I think that people struggle with that. All right, moving on. Timeline. Okay, you know me, I'm all about
you're the detail, very detailed folks.
I'm okay. So going into this timeline, you were there for every day.
Yes.
The bridge guy video.
Yes.
Right, so I don't know if you've seen my latest.
I have not.
Okay, so my latest thing is, since you were there, I want your brain to think about this. Ready?
Okay.
The 207 picture of
Snapchat.
Abby on the bridge. Yes.
Yep.
Okay, so ready? I had an epiphany, and I was like, holy shit, based on Stacey Aldridge's testimony, because I don't know if you know this, but we went ahead and transcribed every single one of your lives. Did I tell you that we did
awesome.
This? Do you know how many pieces of paper I used on that?
I bet it's about as many as I had that I brought home.
Oh my God. It's hilarious. Give shout out to Murky. Every day she's like, we transcribed Andrea's stuff. Here you go. And here I am, just reams of paper, just Andrea's lives. It's hilarious because at the end I could tell you everybody that super chatted.
Oh, that's funny.
So I was you were basically my transcript on the days that I wasn't in there. And so I was like, oh my gosh, this whole 207 that they want to dub at this photo happened. There's actually no proof that this happened at 207.
Yeah.
And so
because they don't have the original photo. They couldn't get it out of the phone. It somehow mysteriously vanished out of the phone. And there's no explanation for that we ever got from any of the forensic folks. It just apparently showed up online somewhere with this 207 timestamp.
Well, and actually in it, I don't know if you went back and ever looked at this, when Ajay did the cross-examination, they're like, where'd that 207 come from? Oh, it actually wasn't 207. Yeah, somebody from the media put it in there. It was because they did a documentary, but it was actually 7 hours, just like the other one said. And so I was like, okay, perfect. And then she's like, well, could another phone have uploaded it? When you sign into your account, you can upload it from anything, any phone could upload your Snapchat. And that's why it wouldn't have been in the phone nor the cache. Okay.
Interesting.
So, yeah. So here we go. Ready? I believe that I've solved the mystery. And I did it based off of what if the picture of Abby on the bridge was actually after the 43-second video. Okay. So, which would make sense to my mind, because why wouldn't Bridge Guy be in the back of the picture of Abby?
be already on the bridge, because we can tell what direction she's facing. She's facing back towards the entrance where you would go onto the bridge from that Mears Road, onto the trail, and then onto the bridge. That's what's behind her, like way off into the distance, and there's nobody on that bridge.
Yeah.
And so a bridge guy had followed her all the way out there, and then is like right behind her at 2:13 when the video starts. He made it across that bridge really fast, is basically the bottom line.
Yeah. And so then I was like, okay, let's take the data. And the data says that Libby stood with her phone, the phone that was extracted. I went off of, like I said, I took everything off of your, everything that you talked about with the steps and when they happened and everything like that. And then compared them to Stacey Aldridge and her extraction when I was there. And what it showed is that there was that pause. And I was like, okay, well, it would make sense then that they actually didn't go down the hill just because the video went off and somebody is saying that down the hill, but actually the down the hill in the original video, remember Stacey Aldridge last night said there was no down the hill. It was just, hey guys, or.
Yeah, she didn't hear that. Yeah.
Yeah. And if you even knew what I got into, and exactly. So I was like, there's nothing that says that actually the picture wasn't taken from a third person that I hear whispering, that we hear like telling Libby that they're on the left side of her. And if that person actually was the one with a phone, they would have actually had the left side angle to take of Abby. And the reason that the bridge guy isn't behind Abby is because bridge guy had already crossed, right? So they're on this side of the bridge, then just standing there, and Abby's back out there like doing her thing like she just was before. So I wanted to know your thought on that.
I mean, it seems feasible to me. It really does. I have a couple thoughts. I mean, the lack of explanation for the Snapchat photo, it's a huge problem. It's a huge problem. One of the hypotheses that seems the most plausible to me is the one that you're pointing out, that it could have been uploaded from a different device, just another device that is linked with the Snapchat account. And so it just sort of baffles my mind that nobody would have gone and gotten the Snapchat account information and you can get the IMEIs of the devices that are connected. And the ISP, the IP addresses and all that stuff to get the device information associated with the account. So that's a peculiar piece of information to be missing from me, because I would expect them to be able to get that. Then the second mess in all of this is the video. Okay.
So
now, Lana, were you in court for any of the videos being played?
The ones I was in court for were all of his interrogations, what they were, interviews. I was in court for that. I was in court for, Bella was actually there at the closing, so she saw it played if it was played in closing there. I didn't get to see that. I basically gave up my spot because it was a mess down there.
Yes, it was.
She got to see whatever was going on with the closing. And I didn't get to see the day that they did they allowed them to say the words. Remember, they were arguing about, can you do that? Can you not? And so they allowed them to have the one officer say the words. Like it basically, you're suggesting what this says.
Yes.
And so I didn't get to see that in the flesh. But I just thought that was, wow. How is that being allowed?
Yeah. Well, so here's the thing. What we were shown in court and were told was the original raw video from the phone. To my recollection, and as best as I can tell from like everybody else who was there and who reported on what we saw when that happened, it's not this video that's been released. It was far shakier. Like it almost looked like a situation where you accidentally hit record on your phone and you're doing other things, because it never fixed on anything. It was really waving around. It didn't even necessarily look like it was a deliberate video being taken. And because of that, you could not see Bridge Guy. And like, we're intently looking for Bridge Guy. We know this is the Bridge Guy video. It's like the one thing we want to see. And they showed us this video twice. And we're just, intently looking, and it's so like messed up. We never saw him. And so then it was the video.
Well, can I ask you a question about that then?
Yes.
So who testified? Who was the person on the stand that testified to the video so that they could be the person that's being obviously cross-examined about it?
I got to check my notes, but I believe it was Chapman was his name. He was one of the ISP guys, and he was the video guy basically. Okay. So,
gotcha.
Yeah.
So he was the guy that did like
the tweaking.
Yeah, he didn't do the extraction. He did the tweaking.
He did the tweaking.
So nobody testified to the extraction of it, never watching it before nobody testified to that video besides Chapman.
I don't remember about later on. I didn't like.
I think that you're right. I think that you're right. Nobody did. The only reason I know this, Andrea, is because I sat and freaking went through 27. I went through all your shit, and so I don't think you missed it. Okay, I just couldn't remember who the person that testified because it was such a short blurb. Yeah, I felt like there was no cross. Does that make sense?
It was definitely Chapman that was this, what I consider the sponsoring witness for those for the videos. There are probably other testimony about the videos. In fact, I remember specifically because we talked to Stacey Eldridge about it yesterday. I think it was Cecil had testified about the GPS data associated with the video. She testified about the GPS data associated with the video and stuff like that. But as far as like, this is the video and here it is so you can watch it, that was Chapman. And so the very first one that we saw that we were told is the raw footage is not what we now know is the raw footage that is, that has been released onto this Free Richard Allen website.
So you've never seen until they just released that on the website. That's the first time that you saw that video.
That video, from my recollection, based on what you can see so clearly and what you can hear. That's the enhanced one. That's the one that was played in closing. And so that, I have a gazillion questions about the video altogether now, because I don't know now what's what. And if that one that we were told is the enhanced one is in fact the raw one from the extraction, then there's a lot of the story that doesn't make sense to me, because that doesn't need to be enhanced. That is better quality. Like, why would you, make something that is less quality than what you already had to work with? It's very nonsensical to me. So that's where I kind of struggle with making sense out of like anything really with the videos, because at this point, I'm not even sure what is supposed to be what.
So did it trouble you to find out that Miss Eldridge didn't actually she never worked with the raw, she just worked with their extraction?
That I expected. That's pretty normal. It's not really that common to go in and do a whole separate extraction of the cell phone, especially I think in a case like this where they have already.
I might like to have the raw data to make sure that it wasn't messed with. Does that make sense?
Yes. What she did testify was that the extraction hashed. It hashed to the data that she had. So so she can say, based on that it's what they extracted on February the 14th, or whatever date it was, hashed to what the data that she had that she was working with. So there was no modification from that.
Perfect.
Yeah. So it's messy. It's messy. I don't know what to make of it. I really don't.
Well, okay. So then we're going to go to, cause we're going to kind of come back to the timeline. So when we add this back in and we go to, Bridge Guy video, Abby Snapchat. Now we got the van, which I was there for this big old, I basically ran after Brad Weber and said, "Why'd you do it, Brad?" Meaning, why'd you lie? Not why'd you kill anybody, but it was a play on words for JLR when he did it to, I forget who he did it to. And I was like, "Why'd you do that?" And I was referring to him. I knew he lied. I was like, this is a lie. Based off of his previous, or he could be telling the truth now, but he lied somewhere. That's, you know, it was inconsistent.
That was clear. I mean, that was clear from the testimony. It came out that, you know, he's just given multiple different accounts of what happened, and he kept changing the time. And then he gets on the stand after having had this conversation with Steve Mullen, you know, to nail down. And that's where, you know, Steve Mullen got absolutely nailed there, because he's trying to distance himself so much from having coached the answer that he wanted, that he says that, you know, Brad Weber showed up in his office and has no idea what they're even going to talk about, but he's just volunteers by himself, and he had gone and researched it and stuff like that. And Mr. Baldwin's like, well, how that is interesting. How would he know how to do that? And Mr. Mullen realized he was caught, and he's like, oh yes, that is interesting. Well, yeah. It freaking is, because you lied.
Yeah,
so
anyway, y'all are tapping it.
It was very clear that he had given multiple accounts, and so who knows which one was the correct one. And so then we get the post-trial motion, of course, and it turns out there's video that can place when his van arrived at his home, and it's not at 2:30. It's like 15 minutes later. And so if the time of that, and also it corresponds with when his phone pinged to the property, which tends to validate the timestamp on that video. And so if that is the case, that doesn't fit the state's timeline at all. The girl's phone stopped moving at 2:32. The white van is supposed to be what triggered Richard Allen to send the girls, you know, across the creek and then murdered them. So it happened at least 13 minutes too late.
Okay, so exactly. So my question with that then is, the defense had the video. Okay, and I'm not trying to like harp on the defense. Like, I love them. I think the world of them. But my question is I know that they wanted to bring the FBI guy in.
Yes.
And they couldn't bring him in via Zoom because Nick wasn't going to stipulate to it, and Gall said, no, you're not going to do that.
Nick actually didn't have a problem with it. It was Gold that made up having the problem with it. Nick actually said he doesn't care if it's by Zoom. He just didn't think that that the foundation had been laid for impeachment, which it absolutely had. But yeah, it was crazy. So Judge Gold said no, and that was
just straight due to the Zoom. Like, if he would have been in town, he could have testified.
Yeah.
Okay, so how about this then? They knew that this video existed. Right? Okay. So my question is, because you would know procedure on, you know, if this could happen, is how would you then, because obviously you can't, well, you could do this. You could recall Brad Weber and say, show a video and say, Brad, is this your car? How would you go, or is this your van? How would you actually go about introducing that video in a way because that was huge for the jury.
Yes. And you know, quite frankly, it's like they should have done that. They really should have.
How would you have done? So, like, I know we're playing armchair quarterback.
Yes,
but in like, if we were on the same team and I'm your little investigator, and you're like, Lana, dig through. We saw that damn van. Find me that van. We need to find it. Get it on. You know, whatever. How would you have gone about it? How would you? So
the way to get that video into evidence, you need a sponsoring witness. You need somebody who can authenticate it, meaning they can testify that this is what it is and it hasn't been altered. It's a true and accurate, you know, representation of whatever. So there's a couple of sources that could be. It could be the person who owned the camera that, you know, had the surveillance footage, and they can come and testify that, yes, I had a surveillance camera and the timestamp was accurate, and police asked me to turn it over, and I did, and I've looked at here, you know, this that you want to show the jury, and it's the same thing that I gave police. Boom, you're done. You're solid.
Or that's one way to do it. That it was off 12 hours because you know, whatever reason.
Yes, exactly. And which is common, by the way. It's very, very common for surveillance cameras to not be completely accurate. You can also potentially get it in from the police officer who went and got it. They can say, you know, as part of our canvas, we, you know, checked the surrounding area, and I contacted this person, and they had a camera, and we reviewed it, and they said it was accurate, and I took it into custody, and here it is. So there's, a couple different ways that you would have to be able to lay that foundation to get that video into evidence.
So, would you have to then say, would you motion into the courts to say we need a continuance, or at sidebar would you say, well, Judge Gall, we need to get a subpoena out to so-and-so because they own the camera. I'm going to have them come in to testify to the camera that they gave it to the police. The police met with them, that they took their DVR. Then I'm going to have to recall Mullins, whoever went to pick it up from them, to corroborate that this happened, this exchange happened. And then I want to play this video for Mr. Weber to identify who would do the identifying of the van, to say, because I thought about it. What if that was played and Brad Weber's like, no, that's actually not my van. My van has black rims. I'm just throwing that out there.
Yeah. So for example, you could have, like, say you get this video in through the police officer. You don't have to show it to Brad Weber at all. You don't have to ask him any questions about it. It's evidence. It speaks for itself. And so as long as the foundation to admit it is in, it can be played. And so, one thing you can do is you can have the officer who reviewed it, for example, testify, or, your own investigator who reviewed it, testify. Here's the entire length of time. Here's the range. Here's
Nobody
where
was questioned about it.
van would have come through in this particular time frame at that driveway that's being discussed. This is the only one that comes in during that time frame. Here's what it is. So it's always circumstantial anyway. The whole point is that if Brad Weber drove his van home and there's no other van on here, then that's probably when he drove his van home. So whether he gets on the stand and specifically will acknowledge, that's my van or not, it really doesn't matter. Because there's not a way for it to be another one that didn't get captured on the video. Okay.
And so to avoid maybe Brad Weber, being crazy style, showing it would be enough, you think, to show the jury to
I probably wouldn't even ask Brad Weber. I would just get it on through somebody else. I would use it to contradict his testimony and not even bring it up with him.
Okay. Cool,
maybe you could, if you knew that you had it already and you knew you were going to bring it in, you can confront him with it. Are you aware your neighbors had a surveillance video, and are you aware that they captured your van? Do you happen to know what time? Would it surprise you if it was 15 minutes later than you're telling us? You can explore that type of thing with him and see what he does. But your ace in the hole is always, you got to have the ability to get that video into evidence. And so you need the landowner, or you need, the police officer who took it in, somebody like that.
And now what if the landowner's just they weren't a disclosed witness, because we didn't disclose them as being a witness. So could Judge Gall deny this on the fact of that? Or
it's rebuttal. It's rebuttal. If you don't typically have to disclose rebuttal witnesses, because it depends on who, you don't know what Brad Weber is going to say. He can say anything on the stand, frankly.
Yeah, we don't know what his testimony is going to be.
Yes, people can say wild stuff out of the blue at trial. It definitely happens. And so you're generally pretty free in rebuttal to point out this, he hasn't disclosed this before. Last time he went on record, he was saying he arrived at a different time. We didn't know he was going to change his testimony. So we have
he's not an expert witness where he would have disclosed his report, and we have our, you know what I mean? Yeah,
exactly. So they can say we have a rebuttal witness in light of what he said now. It wasn't previously disclosed because we didn't know he was going to change his story.
Perfect. And then obviously when we read the motions that Nick has put in, since this time, he went right to the times aren't blah, blah, and there's no blah, blah. Well, I would think that, Nick, that's going to be on you, buddy, because, or your arms, your tentacles, because you're telling me they went and got surveillance camera, didn't get the DVR, and didn't nail down what time the freaking camera was and how long it was, if it was 1 hour early or 12 hours, you know what I mean?
Yeah.
That's just going to show you're inept.
Well, I think that's true. He's doing it because he's playing with the procedure, and the procedural posture, and who has the burden of proof at what stage and so forth. And so since the defense wants to use it, they have the burden of authenticating it. And his negligence in that case would inure to his benefit. So, yeah, of course, you would expect that the police would have checked that kind of thing out. There's probably a report somewhere for whoever it is that did go and collect this video that talked to the homeowner that would have, had that conversation about does it line up or whatever. At least that's pretty routine with this type of video evidence collection.
100. Okay, cool. So we're at, okay, perfect. We're going to move, here we go really quick. Let me go to this one. Okay. Ron Logan, Odinist defense theory. In a 1 minute kind of, do you think that this, this is no, we're second half quarterbacking, whatever, Monday morning. Did the defense make a blunder by not just focusing straight on Ron Logan versus going the Odinist defense theory, but taking into account the crime scene? Obviously, we know, I believe it's indicative of multiple people. So I don't, like, my personal opinion is they didn't fail, but after I heard the juror talk about this, oh my God, who else could it be on the bridge if it's not Richard Allen? When I heard that, I was like, you got to be kidding me.
Yeah.
That's not our job.
Yeah, I know.
So like when I heard that, I'm like, well, gosh, if they would have known about Ron Logan, then somebody like that would have been like, okay, yeah, it could have been Ron Logan because he lied about his alibi. So I kind of wanted to hear like, how would, I know we kind of talked, where was the point that you thought that they should have pushed the envelope of third party culpability?
Well, so the problem is that Ron Logan was excluded in the motion in limine pretrial already. So they had brought him up. I don't remember if it was the third or the second, the motion to present the third party culprit testimony. But that was really the limitation they were always going to have. And so the problem that they had here, they didn't get anything new really about Ron Logan over the course of the trial. It wasn't until after trial when they found out that new information or found this tip. Yeah, that was kept from them. Although, again, with that, it's a little bit kind of confusing in the record because it does sound like they were aware that there had been this tip, but just because Andy had gone and talked to him before trial, and he said, he hadn't really said anything, and so, but he had said to go and look at his recorded interview that he'd already given to police. So then Mr. Baldwin contacted the prosecutors, Ms. Diener and Mr. McLeland, asked them for a copy of the video. Apparently, never got it, and apparently it just fell off the radar. So. Should they have followed up on it? Yeah, they probably should have. And that's, again, another one. It's like, it's hard because we have the benefit of hindsight and we're not trying to, Monday morning quarterback and be overly critical, but like, now knowing what we know and the need to be able to meet the apparently unmeetable burden of establishing a nexus that Judge Gold was just, not going to find anyway. Nevertheless, being able to make the record of the potential connection with Ron Logan, it's his property. He's got the false alibi. He's volunteering the false alibi before the bodies are even found. He's got the pinging on the property, and now he's got additional statements that are extremely incriminating. He is talking about who has an artery severed in their neck and who doesn't, before like anybody has any reason to know that. And that was true. That came out at trial. So, I mean, you want to talk about detail that only the killer would know.
Box cutter?
That's a pretty significant one. Yeah, the box cutter, all that stuff.
That was nuts. When Baldwin was like, wait, and Rosie's like, this is not what you told us in a deposition. Yeah. Unreal. Yeah. Just changed his mind, that epiphany in the garage, the medical examiner. Unbelievable. Okay, so then now you had the pleasure, which I was so busy doing Kohlberger stuff, I actually had to watch your live with Bob and Allie, which, by the way, love them.
Yes.
Defense Diaries, if you guys don't know. They had Stacey Eldridge on. She was the defense witness, the expert for the phone. And Baldwin says, actually, who did the opening? Was it Baldwin? He said that, hey, human hands would have, like, I think you like touched the phone, or there was involvement with human hands in the phone, and please wait for us type of thing. And and hold the state to their, to their timeline of when this happened.
Yes.
Don't let them off on the hook. Okay.
Yes.
So I was there that day when I heard her say that, boom, it plugged in the jack, and it, and then it plugged in at this time at 4 or 5, whatever, and then came out at 10, whatever. Like, did you remember hearing like that? Like
yes.
I was like, I remember that, like, it's never going to go away in my mind.
Yes.
This
that was huge. I mean, that was huge.
And that's when I was just like, it's done. It's over. Like,
it blows up the timeline. It completely blows up the state's timeline, because it doesn't make any sort of sense with their theory of the case.
None. And
the timeline is messy enough already. We just have so many pieces that we have to try to cram together to fit. And, with the short timeline to commit the murders. And, but then it's like an hour later when he's supposedly on the road, being seen by Sarah Carbaugh, and, all that. And the fact that his car is not where it's supposed to be, like, all that stuff. It's always been a mess. But this just completely blows it out of the water, because nobody is supposed to have any idea that they're there at this point in time. So how is anybody interacting with the headphone jack?
How do you miss this in a logical extraction? It was there. This wasn't like.
Yeah, and she says it was there, and I mean, I remember from the testimony. I remember from the evidence. It's there on his report. And he had acknowledged it, that it existed, because he had to try to explain why they did this additional extraction. See, they had additionally only extracted the phone up until like 4:30 of the afternoon, or maybe 5:30 or something like that, when the phone.
Yeah, it was like till 10. It was till 10.
Like when it lost connection with the network.
It lost power. That's
it lost the connection is what happened. It stopped connecting to the network. It was when the pings stopped connecting with the phone. And so they thought, according to Cecil, they thought the phone just died. So they only extracted it that far. Well, then they went back later and they did the fuller extraction with the new version of Celebrite, and they found there's additional activity later on. And so he had to specifically acknowledge he had this code in his report, because he says, yeah, we discovered there had been activity in the phone at 10:32 p.m. that we didn't previously, know about. So he knew that it was there. He knew that it was there.
That's why I don't believe it.
He just either didn't believe it, or, didn't want to, didn't want to go to the trouble to like verify what it was, because it's so damaging to their theory. It's
so damaging. And then to seriously sit there, I will never forget this until I die. I'm telling you, to seriously sit there and somebody testified to a Google search, I couldn't even believe it.
Yeah.
That when I was out there during the break, I Googled and
I googled some user support forums. Like, this is not the same thing. Like, what happens when you're trying to get your headphone back to work has nothing to do with the code that the phone is writing when you're trying to make the headphone work. These are two separate universes. It was unbelievable.
I loved the fact that, okay, well, it still doesn't explain. So the phone was on, okay, because this couldn't have registered if the phone was off, right? Like, regardless, the phone had to be on, correct?
Yes.
And then, so please explain to me, this is what happened in the damn Chris Watts case, when Shanann's phone started getting all the calls that come in because the phone was shut off, and then when it was turned back down, it just started blowing up. It was the same type of thing where all these SMMs started coming in like this. And when you compare those to then the actual person that sent them, and you see when they're outgoing, when they actually sent it, that's how you were able to realize that, oh, wow, this phone was off at least by this time, because that person had sent it at this time from their phone. So I was able to do things like that to be like, okay, wow. So that's what it reminded me of. With this case, it reminded me of the Chris Watts case when everything came on and did it all at once. Dude, that's a typical power on move.
It is, but it can also be it can also be an airplane mode on mode.
Well,
like when
like a handle. Like there's no way that's happening without you physically changing something.
There's some kind of, I mean, okay, so the only way that Stacey Eldridge seemed to think was possible is, okay, if it's a connectivity issue, it is also possible that the connectivity is at the tower, that the tower is down, the tower is not communicating with the phone for whatever reason. And then if the tower would come back up, you'd have that same kind of phenomenon because you'd have that sudden reconnection to the network. Well, the problem is AT&T is pinging her phone the entire night. Don't you think AT&T would realize if there is something not working at the tower end? Like you would expect that that's something that they would be aware of. So it just, and yet again, nobody seems to have went down that rabbit hole to try to find out, like, are there tower service records? Is there anything like that we can get to validate that these pings were actually leaving the tower? The problem was at the phone end. That didn't come in at trial. And so if it's not happening at the tower, it is happening at the phone, and that needs to be explained.
I think
it's not something the phone will do itself. It has to be something acting on the phone. The phone is in a bag. The phone is, a Faraday bag. The phone is being placed into airplane mode. The phone is being turned on and off. Like, these are all explanations, but they all involve some kind of interaction with the phone by an actor.
Yeah, not a ghost. All right, we're going to move on from, I think, we're going to come back to the last thing I want to end with, or here we can just do it really quick. Did you listen to the juror interview in this case? I didn't.
I did go through and read the transcript.
Okay, so perfect. Enough said with that. My question then would be this: as a defense attorney like you are, are hearing those things helpful? Like, right?
Well, it is. It's very frustrating. It's very frustrating because, it's not how the system is supposed to work. It's not really consistent with the instructions and what the instructions tell you to do. But the reality is the juror is kind of the boss, and they don't, there's no way to like audit them. They get it right or they don't. So it's helpful to the extent that it makes it clear that there's a communication breakdown with making sure the jury understands what exactly they are supposed to do. And it seems that they did not really internalize what the standards are and that type of thing, what the real project is when you're making the decision about whether you're voting guilty or not guilty.
Okay. So her commenting on the clothing that was worn by the defense attorneys in the state versus, like, I don't know if I would ever even mention that. Like, that would make it seem like that I'm paying attention to things that don't matter.
I do kind of expect that. I mean, that again, it's normal. These are human beings. I talked about Brad Rosie's clothes.
Okay, well, you're being a journalist.
I was actually once in a trial where a juror ended up getting disqualified because I was leaving the courtroom or I was leaving the courthouse. It was like a while later. And for some reason, I think she had hung out there for something. She was leaving the courthouse, and so she kind of passed me, and she said, "Hey, I love your shoes." And so I had to report this to the court because, the juror is not supposed to be communicating with me. And so the juror ends up getting stricken because you're not supposed to have communication all over about a comment about my shoes. So, yeah. I mean, it's normal. Things happen. These are humans. This was a long trial, so there's a lot for them to think about and pay attention to.
She brought a camera with her. She was trying to put a camera in her bag that was a disposable camera. I'm sorry, I just had to get that in. Like, dude, I feel like we're going on Survivor, and like we gotta who's gonna be the last one? I don't know. Like, I just want to give it anyways. But so okay, so then the Karen Reed case, we're going right into. Well, the way that we're gonna do this is I want to keep Karen Reed last. So
okay,
I was just gonna say about the Karen because the jurors kind of came out in that case too.
Yeah.
But, we're gonna go right now into Idaho 4.
Yes.
So, okay.
Oof. boy, the flood of Idaho 4.
Okay. All right. Exactly. The flood. So like where to begin? All right. So I had emailed you because I was like, hey, what do you think about us talking about this and that? And for me, I want to hear it from a standpoint of we can all say, why are they doing this? Or why are they doing that? Or come on, like, how about this? How about that? At the end of the day, like, it's like the Monopoly board game. Okay. There's rules. You can't just do something. So for me, how I kind of envisioned it with the people that are normally usually here, I had sent Andrea and I said, let's see. Okay, so here, I'll just rattle them off. So what happens? Okay, so what happens now that the state admitted? I don't know if you know this, but the state admitted in a filing that they got to Bryan Kohberger solely off of IGG.
Yes.
So we've already went through a suppression.
First time they ever heard of him, December 19th.
Yeah. And just right here in the motion Limines, we hear, hey, guess what? We're going to announce to everybody. We solely got him off of IGG, not WSU and all the BS that Hitler wrote in his order. So saying it was a fact that the investigators got to Bryan in part by WSU identification of his car without a front license plate, it's all crap. Is there
That's not how they
anything
got to him. That's how they charged him, but that isn't how they identified him.
Correct. So my question would be with that is the state wants to be able to use this generic tip by just to say, hey, we're not going to say who, what, where, when, it's just, we started about in this type of a case. How is that even possible without lying to the jury?
Well, it is very misleading. And I think the only reason this is particularly complicated in this case is because the defense doesn't really want to mention the IGG either. It's like
they don't want to either.
No, they don't want to either. And so they're
I disagree.
They're between a rock and a hard place because, the problem is the IGG sounds like confirmation of genetic proof that Bryan Kohberger was there and is associated with the crime or whatever. So it's something that, they're not going to want to emphasize either. But no, they are not. I mean, I think if there's a choice between, do we just go with this generic, we got a tip versus, we got his name from IGG and then we went and checked on all this other stuff. I think they'd prefer to go with the second.
Well, they said that they're not going with either. They said that, oh, hell no. So the defense came back, Picca Barlow comes back and she's like, oh, we welcome how you think that you're going to say this without lying to the jury. Yeah. Because we're
that is really the problem. There's not a viable way to communicate that isn't misleading, because a tip sounds like somebody new. The tip is going to make it sound like it's got so much more weight than in fact it does. And it's just, it does. It creates a risk of a very misleading type of inference for the jury to draw. And it's particularly damaging too, because normally, like if police get a tip in a criminal trial, they don't get to tell you that in trial and rely on that. You have to produce the freaking tipster because you have a right to confront the witnesses against you. And if there had actually been a tipster, then you need to, put the tipster on the stand. I mean, that might be fine. Put the freaking IGG person who produced the result on the stand to say, I'm the one who told them you should look at Bryan Kohberger. Maybe that's like some kind of a middle ground compromise there.
Oh, no, I think they're going somewhere else with it. Ready?
I mean,
I think that they're going to say that, hey, use your probable cause affidavit. That's how you got to him, right?
Yeah.
And so then this is where I'm coming in is
it's not. That's the thing. It's not. And the defense should have the ability to challenge that, because it's not. And they've admitted in their previous hearings, they're going to have Brett Payne's sworn testimony that I never even heard Bryan Kohberger's name until December 19th.
Okay. So ready for this? I think that I believe that Ann Taylor did what I call like tic-tac-toe, when I can either win this way or that way, depending on what you do. Yeah. So if you're going to go ahead and lie in this suppression hearing, right? Yeah. And you're going to continue to stay with your lies, then we're going to have you right by basically the balls when I go ahead and say, well, we're going to pull the IGG and we're going to agree with you that we don't want the IGG in, just like you don't want the IGG in, right? Mm-hmm. So now without the IGG, what do you have? And that's where I'm just like, holy shit, I think that this would remove the sheath, but I really got to ask Andrea because I want her to hear my logic and brain. And then for her to say, no way, Lana, that would never work. But this is why I say it.
Yeah.
It's because if somebody's on the stand and we're not allowed to talk about IgG, and you're just going to say, oh, you got to Brian Koberger, and you say, oh, we matched his DNA. What'd you match it to? The sheath. Well, how did you do that? Oh, well, we extracted it, and then we ran it through, we were able to get STR. We ran it through CODIS. We didn't get a hit. And then they said, hey, we want to go ahead and do this in, investigative genetic genealogy. Like, I think what Ann Taylor has created through Bicca Barlow's help is that how are you ever going to be able to mention the sheath without talking about IgG?
Well, I mean, I know what the prosecution is going to want to do. They're going to want to just talk about the sheath and the extraction of the profile and the STR analysis that they did and ran it through CODIS and didn't get any match, and then they just followed other investigative leads. Leave it generically, and then they got a tip. And well, let's say we can't do that. Okay, we can't talk about the tip, so we just followed other investigative leads, and then ultimately we ended up with Brian Koberger. His name and in Pennsylvania, we were able to do the trash and get the STR profile, basically once we swabbed his cheek. And so we know.
Why would you ever swab him, and why would you ever go to Pennsylvania?
Because they had a warrant and they got his name.
How'd you get his name?
They followed other investigative leads. They'll do some bullshit like that. So you
think that's going to happen?
Yeah. The question is going to be how. I think the question is going to be how, and I think the question is it going to be, are they going to be able to do it in a way that doesn't open them up for very damaging questioning by the defense? Because like you're pointing out, we have these facts now that we know. And so if they're going to get on the stand, they're going to be like, oh, we followed other investigative leads. We'll describe some of those. They want to try to mimic the probable cause affidavit. And so they want to be like, well, we had gotten this information from WSU and we did the search for the Elantras.
When did you do that?
Yeah. Well, yes. And so the defense can lay all this out. Yeah. They can say, but Mr. Payne, Detective Payne, you testified under oath. You had never even heard of Brian Koberger until December 19th. But now you're telling this jury here under oath today that you got Mr. Koberger's name from WSU back in November. Were you lying then or are you lying now?
Woo! Give her some cowbell! Yes. And here, I'm going to show you the little piece of the document that, hold on, I'm going to go like this. I'll share Hector with you. Hector, come on in. And this is where Bicca Barlow dropped the bomb right there and says, well, the state agrees with the outcome of the motion and has agreed not to present any evidence of IgG on the process. In its papers, the state says that it can present evidence of a quote-unquote generic tip without revealing the source or substance of the tip. Mr. Koberger welcomes this argument and asks the state to identify the specific witness who will testify and the specific testimony that will be given, because since this testimony will be quote-unquote will be sanitized for the presentation to the jury to avoid the IgG process. But oh wait, hold on. It must also not falsely suggest that they were aware or got him through anything out. How do you do this? And you guys, this is what I'm talking about, is the toe tag double dip tic-tac-toe that they just performed.
Well, when I read this is calling out the confrontation problem. You have to you don't just get to say we got a tip. That's a confrontation problem. He has a right to confront the tipper. And so who are you going to put on the stand to say I gave this tip, and what is their basis going to be for the tip? You're gonna have something that isn't a lie, and if you don't want it to be IgG, you need to propose something sanitized.
So let's play. If you're the prosecutor, what would you do if you're the prosecutor?
I mean, you might try to just frame it in some type of general. We did genetic research, or we did family research or something like that. I mean, we started from the genetic information that we had, and we did family. Like, I don't know. I really don't. This is a very tight little skillet
unprecedented
that they have to navigate.
This is so unprecedented in my opinion, because it's touch DNA that they're using the IgG with, and there's nothing else that, usually like it's a boyfriend or like like when they're like the John Ramsey case comes to my mind.
Sure.
And remember like the whole DNA that was on the underwear, but then they were like, oh, it's touch, and it was from the person that did the packaging of the underwear because she just put it on it for Christmas and all that stuff. Yes. I'm like, dude, this is exactly what this is in a way where, wow, like, they didn't do IgG then, and he's been begging for them to do IgG. Yeah. So I'm over here just like, wow, I think that how do you ever get to talk about the sheath though, and not mention that you used IgG? So
because the sheath itself is independent from the IgG. The sheath, the sheath was there at the scene. The sheath is independent in and of its own right. The IgG is going to the identification of that evidence that they got from the sheath. And so it's like, I don't think it takes the sheath out of play. It just,
it doesn't have to play. I said that wrong. My bad. What produced from the sheath that's how I want to say it. The sheath the STR. Play, but what produced from it?
The STR. They want to be able to use the STR and not have to get into the SNP. That's really it. And the STR is typically valid. That is typically valid. The question just is, how did they, square the circle of getting that genetic profile initially to having Mr. Koberger on their radar to be able to get the cheek swab? That's what this is getting to. You don't get to pretend that you just didn't do this and that this wasn't the driving piece, because we have Payne under oath saying we never heard of Brian Koberger until December 19th.
So when Hitler says this in an order, do you think he's just like throwing up right now when he says there can be no question that the defendant was identified in part through the WSU officers' queries and through the suspect vehicles? Come on.
I don't think he's wrong, but he's just being very, very tricky, because the reality is that, yeah, sure, they did after the fact, after they got his name from the IgG, then yes, they went through and did the reverse engineering.
But that's not what he's saying. Is that what he's saying here?
He doesn't talk about the timeline. He's just saying it factored into their decision that it was Brian Koberger. Yeah.
Okay, so there can be no question that the defendant was identified in part.
So I'm sorry?
So when he says there can be no question that the defendant was identified in part through the WSU officers' queries,
I think that's
through
fair.
The suspect vehicle?
It's tricky, but it's fair, because that is what they did. They got his IgG, and then they went to build the case against him. And so they got the WSU, and they got the video, and they tried to tie it to his car with here's the one with the no front license plate, and here's his phone, and all that stuff. All that other stuff that they did.
Interesting. So I think we're kind of in the same boat when we say that
this is very clever. It is very clever. And yes, this is a great maneuver. It is throwing it back on the state. Make it clear exactly how you're going to do this in a way that satisfies his right to confrontation and does not mislead the jury.
And so do you
something and then we can talk.
Yeah, how do you propose that we do this? And like you just said, but we're not going to be misleading the jury like you just misled the magistrate with your probable cause bullshit, right? And that's kind of how I read it. Or I read it as, please.
Well, it would be misleading if they present it like the probable cause affidavit does, where they suggest this is the order of events. That's not the sequence of events of the investigation. They have to be clear and not misleading about the sequence of events. That's what the defense is prepared to cross-examine them on. So they can't just
there's an investigation.
What's that?
Like you do any other case when you confront somebody about the investigation in itself.
Yeah. So say you have Payne on the stand and he's trying to testify, consistent with the probable cause. And he says, well, on November, whatever, WSU ran their search and they found the Hyundai Elantras and they sent it to us. And one of them had Brian Koberger on it. Defense on cross-examination is going to be like, so when did you first discover that Brian Koberger, in the timeline of your investigation, when did you first look at that video? When did you first look at that identification and involving Brian Koberger? When did you first connect that particular vehicle at WSU with because it's going to have to be after December 19th.
Well, ready for this
And
question?
if he says something else, you're going to be able to say, but Detective Payne, you said you'd never heard under oath in another proceeding. You said you had never even heard Mr. Koberger's name until December 19th.
Ding, ding, ding. So here we go. Ready? How in the world then did they get WSU videos that would have been preserved after a 30-day period? Because if I don't know about somebody until the 19th, if I try to, hey, let me go get all this video surveillance to try to oh my God, we got to see if this white Elantra was all over here. Where did this WSU, the dates and timestamps of when you went and preserved the WSU footage? That's the ticket I want. That to me is going to be everything. And I think it's going to expose truly when the feds knew about Brian Koberger.
Yeah, no, I think that's very true. Yep.
And that to me is going to be everything, because if you look at every report, they refuse to say when so-and-so did what in this case. And timing of when, because it's all going to come back on the priorities in this case to me. If I'm the lead investigator, hey, Sue, you need to go get this. Hey, you need to do this. I'm telling people what to do based on priority of what we need. And when did it become a priority to go and get WSU's cameras? And how would they ever still even have footage after the 30 days?
Yeah.
So you just nailed it with testimony of Brett Payne. I was going to ask is the testimony of Payne and Mowry in pretrial motions. Yeah. How will this affect them when testifying at trial? Do you see the FBI people testifying way more due to the fact that Payne and Mowry blew themselves away in pretrial testimony?
They can't get away from Payne. I mean, he's the lead guy, and as much as the FBI did, they didn't do the whole thing. And so I'm still kind of curious to see, just because there were so many issues with the TUI and the federal resistance, particularly with the cast stuff, and it never quite got sorted out real clearly if there was a little bit of maybe a difference of opinion and parting of ways when it came to how that CSLI testimony or that CSLI evidence was evaluated first for the probable cause affidavit and then later by Mowry to go to the grand jury. Kind of sounded like there might have been some problems between them when it came time to prepare for the grand jury that the FBI was maybe not necessarily on board with. So I'm very curious to see how all of this plays out, because the potential for triangulating the FBI against the local investigators, that's a great place to be as the defense lawyer. You can drive the wedge between them. That's a good place for you to be sitting.
Heck yeah. I think you're going to love all the new documents.
There's so much. God, I'm like so behind. I have so much reading to do. It's crazy. It's been such a flood. What was it? 40 some the other day. It's like 30 some, yesterday.
It's all the motion of Limines. So everything from February 21st. Then the state put in theirs on the 21st, then the defense put theirs in on the 24th, and then they all had to answer to each other. And then that came out on the 19th when he just dumped, that all. Yeah. Next question, Andrea, ready?
Yes.
Okay. Thinking of the bridge guy and how the jury was like, if bridge guy is the killer and we're going to make Richard Allen bridge guy. Okay. So with that philosophy in mind.
Yes.
So it's kind of like the bridge guy here is if the jury doesn't believe that Brian Koberger's car is the 3:26 a.m. vehicle that is first spotted in and on Indiana or Indian Trails Hills, whatever. Is it then curtains? Because if the car that they say is suspect vehicle 1, you're that has to be everything to the jury in order for it's like a domino. Without that domino, you don't have anything else. So the jury has to believe that the video of Brian Koberger's or this vehicle at Indian Hills at 3:26 is Brian Koberger's vehicle in order for everything to flow.
Well, here's the thing. Like as we saw from the Richard Allen trial, the jury is pretty good at deciding like selectively what they want to believe in and not to believe. And so they could very well decide, well, maybe they didn't prove the Indian Hills one, but it doesn't necessarily undermine the 404 one at King Hills, at King Road, still being Brian Koberger's video, or still being his car. And so the problem, I think, is that if the FBI can only testify that the one on Indian Hills Road is the one that we're saying is the 2011 to 2016 Elantra, and everything else is like too ambiguous to be identified. Yeah. So necessarily it has to be the same car. And if they don't think that's his car, it sounds logical. It's just that juries don't always think that rigorously. And so I could see a situation in the jury room where if they want to believe he's guilty. See, that's kind of what it always comes down to is sort of, it's the motivation of the jury. If they want to believe he's guilty, they can rationalize around that however they want. And they can say, no, maybe that one wasn't his. Maybe they got that part of the analysis wrong, but we still think it's his because of the cell phone, or whatever. And as it's so sus that we turned off the phone, which like, of course, is not even what the PC affidavit says, but, and then the trace DNA. I mean, that's the bottom line is the trace DNA. That's the ace in the hole, so to speak, for the prosecutor. People are going to potentially find that extremely compelling. And so the jury, if they buy that and they're like, DNA, that's it, we're done, then they can rationalize around all of these other pieces, and it won't necessarily make that much of a difference. That's my view, which is unfortunately maybe a little bit cynical, but it's just, like I said, we kind of saw that in the Richard Allen case.
Well, the thing that we didn't see in the Richard Allen case was this: male blood DNA belonging to other people at the crime scene. Where is the jury going to place this, and how is how does the prosecution say we don't even think this is relevant and we didn't even test it?
We didn't even run this in CODIS. I can't believe this. And the explanation. Okay, this is ridiculous. I wrote about this on my Substack because it's so insane.
Yes.
Like you would think that these are public databases. They are public record, the manuals for like the rules and standards and stuff like that. They're all out there everywhere. They're very easy to find. And of course, CODIS does not say you can only put in, one DNA profile per crime.
Can you believe that?
Multiple perpetrators. You don't even freaking know if this case has multiple perpetrators or not. And perhaps in part because you never bothered to put this blood in the CODIS and follow up on what, that might have told you from an investigative standpoint. So, for me, it's such an alarming omission. It's completely inexcusable. Their explanation doesn't make any sense at all. It doesn't make any sense. Like, you are either the most inept people ever, and you never bothered to ask, like, what the people at the FBI that do these types of investigations all the time that might be able to clear it up for you, that, like, yes, of course, if you think it's attributable to a suspect, you can put it in CODIS.
Yeah, it's foreign. Yeah, there are rules, but like it would beat the rules. Like, it's foreign DNA.
Yes. It meets the standards for entry into CODIS. And so, like, why it does not make a lot of sense. And so,
and they're married to that. He's married to that answer, right?
What's that?
I mean, Payne said that's what he's like.
Yeah, he said under oath. He's stuck with that. Now, though, he was very squirrely about it, right? Well, as best as I can recall, and if memory serves, he very, very qualified it, right? So that he gives himself that leeway to be able to back out. The problem, though, is that if he backs out, great. So you were wrong. So then what's the real answer? Yeah, you thought that's what you remembered, but that's not actually what happened. So then what's the real answer for why didn't you put it into CODIS? And if you never had this conversation, because I'm really doubting you had a conversation like that.
I'm doubting, because you wouldn't know if it would be one perpetrator or two or three. You know what I mean? At that point, like, you would be thinking,
who was not suspecting multiple perpetrators, just giving the nature of this crime? Who would not suspect that?
Yeah, I mean, especially with what they knew, and like, we're just the public, but hey guys, this had to happen in 13 minutes. Like, damn, who did this?
Yeah.
Well, oh yeah, gosh, we got all the look at it came back and see, it's I think gonna be like a little sting, like, okay, well, December 17th, you found out that there was these unknown male blood. I mean, we're talking blood. And
blood.
It's a stabbing. 4 stabbings.
Yeah.
So I think that's going to be interesting to me to see how the jury kind of like is like, wait, what? Okay. Next up is everybody wants to talk about it. And I know they want to talk about it. So here it is. What do you think about the fact that the K-bar knife and sheath are not being labeled as being the make and model that has the military logo on its sheath in the filings? Would you, as a prosecutor, be labeling it as such to say that Brian Kober purchased the U.S.
exact same?
You would like,
you
what
would
would be
think
the reason not to?
You would think you would at least put in some kind of description that it's equivalent to the one that was found at the scene. Right. You would expect that. Not just any K-bar is not necessarily incriminating, but if he's on record as having purchased the one that's associated with the sheath that was found at the scene, which is a specific item, that's not good. That's definitely, it's not necessarily, the end of the world, but it's not good. It's a very bad fact the defense would have to deal with. So yes, I would have expected them, especially given the context of that argument, where they're trying to say, like, this is why the Amazon click history is relevant, because it's in the context of this other incriminating, piece of evidence that we're introducing. Then you would highlight, like, this is how incriminating it is, because it's the same type as the one that was found at the crime scene. So it's not dispositive.
Exactly.
They could have just not, for any number of reasons. I don't know. I'm not a prosecutor, and I don't want to try to read their mind, but it just, yes, logically would make sense to me that if that were the case, you would mention it.
Yeah. Right. I mean, that's what when I was reading these, I was like, why aren't they saying that Brian Kober purchased? Why are they just saying a K-bar knife sheath and this sharpener? I buy all of my paper through Amazon, and they get it to me like literally, if I buy it right now, I'll have it tomorrow between 4 and 8 a.m.
Nice.
And I buy them in reams, like 1,500 pages at a time, like the big stacks. Well, they always say, do you want to add on filing freaking things for my filing cabinet? That's always like a damn add-on. Okay, bundle this shit, Lana. And so I'm over here like, I was really, really interested to find out that, because as a YouTuber now, Andrea, you're a YouTuber. Like,
God, I am.
Yeah, right? Paying attention to the whole algorithms. And I was like, what does that even mean? What do you mean? I learned the hard way that when somebody's like, they at your channel, they go at, Truth and Transparency. Dude, that infiltrates my algorithm. And then
I didn't know that.
Oh, yeah. Like, I had to learn all about this because I set a precedent in Colorado that if you at somebody, that is me contacting you.
Oh, geez.
That's a form of contact. And that is a way that you are stalking and harassing somebody, allegedly.
Boy.
Wild. I'm like, wait, excuse me? Hashtag? I was like, wait a second, this is insane. Anyways, what it does, though, if other people did it, let's say that they made little shorts about you, Andrea, and made them like, making you into like a clown nose and blah, blah,
do the thing they do, the little nasty things they do. Sure.
Yeah. So when they're doing that and like hashtagging your name and and then using the @ symbol to your channel, that will infiltrate your algorithm. And then what will come up is videos that they made will be like in a recommendation for you. So then I was
interesting.
Yeah, I was watching or reading, and I was like, wait a second, they're talking about Amazon clicks, and then it's not like a Google search. And when you click on something, it's not what you think a click is. And so I was like, and then they're doing AI and how AI is generating stuff. And I was like, how Hitler thinks that he's going to rule on something without hearing from the professionals, the experts, because how would a judge even know about that? I don't know about that. We don't know about it. How would a judge know about it? Like, these lawyers don't know about it. Like, we're lawyers, not, that's what I would be saying. If I was a lawyer, I'd be saying, dude, I'm a lawyer. I'm not an Amazon or a eBay expert. Like, I don't know how they're doing stuff, but that matters.
Yeah. Yeah, I found that not taking testimony. I did find that to be a little troubling. If only just because, if for no other reason, like, yes, you would think you would want full information to make your decisions, because we were trying to be conscientious about it. And we have, we're aware of the limits of our knowledge. We have epistemic humility. These are the kind of things that you want in a judge. But if for no other reason, this is a freaking death penalty case. You want a record. You want a record. You don't want there to be something out there that the defense is now going to raise on post-conviction because you didn't let them make their record, and, have it potentially be the basis for a new trial. So it's alarming from that standpoint. It just makes a lot more sense to do it. And I'm a little bit baffled as to why he's not.
All right. Well, I'm with you on that. But also I know that motion limines, they normally don't have testimony, but is this where there's our exceptions to those rules, and this would be one of those?
Oh, absolutely. And it's actually, I would disagree with that too. It's not uncommon at all for motions in limine to take testimony, because you're often dealing with an offer of proof. But the whole point of a motion in limine is to kind of pre-litigate the admissibility of something. And so sometimes you need to have an offer of proof about what exactly is it that we're talking about. And so yeah, it's not uncommon at all to have some type of preliminary testimony for deciding a motion in limine.
Okay, so with the motion limines that is going out with, well, we're about to get to Karen Reed in a little bit here. Then I have some questions about that then. Cool. I think maybe it's, I don't know, I can't remember the last case that I was covering where was there witnesses with motion limine? Can you recall off the top of your head that would be like a popular case?
Oh boy.
Well, we'll come back to that.
Not this time of the day.
You're like, Lana, come on, it's our birthdays. Wait, what else I got here?
The problem is that I'm one of those people, my brain kind of starts shutting off at like 4 p.m. I'm like, oh, it's nap time.
Oh, Bev. Oh, stop being a Bev.
I know. Like an alarm.
Right? Bev's like, oh, it's one done. Dude, we're doing halvesies. The whole Karen Reed child's taking all summer because Bev's doing halvesies on the Cape. Like, woo.
Yeah.
Okay.
DB, I see in the chat pointing out, the Delphi 3-day hearing in August 2024. Yeah, the motion in limine on the third party culprit stuff.
Oh, so they did. Oh, that was for that? I thought that was just for. Okay, there we go. Boom. So Judge Gall even let witnesses talk. Yeah. Wow. Man, if you're out doing Judge Gall, man, woo! There you go. Okay. Have you heard about the text messages? Have you heard about like 911 calls? Like anything about that?
Oh yeah. I've definitely seen that stuff. Mm-hmm.
Okay. So question for you.
Yes.
All right. The state wanting to basically say, we're going to play by the same rules as what we did with the grand jury. And they just admitted this stuff in, like it was, excited utterance or present tense, right?
Present impression. Yeah.
Yes. Mm-hmm. So here, why would even the state even think that this would fly again when, okay, yeah, they probably went through their phones. They've probably seen some stuff, but we're just going to go ahead and put this timeline in front of a judge that's not accurate. Mm-hmm. Like, for example, at 3:51 a.m., Dylan added a contact to her phone at 3:51 a.m., but told investigators that she was sleeping between 3 and 3:20. Yeah. So my question would be then is, it's going to be so hard to cross-examine Dylan and Bethany. How does a defense attorney show sympathy to the fact that there are surviving roommates? Okay, your roommates were just murdered. And how do you, though, this can't be honest. Like, how are you sleeping at 4 and you were just awake putting a phone number in your phone?
Yeah, the answer to that is you save that for your argument. When you are dealing with the witness, you're just dealing with the facts, and you don't have to be mean about it. You don't have to slap them with it. You're just dealing with, this is what the reality is, and so here's what you testified to when you told them that. And you can even, just depending on the circumstances and what your theory of the case is and what you want the jury to think, you can play it up and be like, look, I know that, I can't even imagine what sort of experience this was for you. I can't imagine how upset you were and how horrified. And so, I can imagine a lot of reasons why you might not necessarily have gotten everything exactly accurate, and that it wasn't you trying to like be misleading, or it wasn't you trying to be dishonest or anything like that. It's just that you're under an enormous amount of stress that most of us will never have to deal with in our lives. And so, take that into account when we're talking about, you said this and the police, relied on that. But fact, we can see from your text messages that this is what you were doing at that time. You weren't in fact sleeping. You just try to keep it as clinical really as you can. And not
do you ask them
to say, you were wrong. You were dishonest.
Do you say that for like the cops, where do you say like, did you guys even bother, do you maybe like hammer them versus like saying, how did
potentially, or again, you just save this stuff for your argument. Like the thing is about cross-examination, most of the time it's way better it's a show don't tell process. You get your facts out in the cross-examination. You don't need to editorialize on them. The facts usually speak for themselves. If you're good at presenting them and eliciting them, the facts themselves tell the story. And so the jury already knows what the conclusion. They already know, oh, she's inconsistent. Like, you don't have to tell them, you've shown them. And so it's then when you get to your argument that you get to make sure that that's clear, that they have followed that when we talked to Dylan, she was under a lot of stress, wasn't necessarily her fault, but she had told the police this. And in reality, that can't be right because here's what her phone said.
And so would that be your same strategy if you were labeling them as one of the third-party culprits?
If you're trying to present them as a third-party culprit, that's a really, really tricky situation.
It tough? Is it like a Jen McCabe situation or no?
Well, no, I wouldn't expect it to be, because I wouldn't expect these witnesses to present like Jen McCabe. And they're in, they're in a very different setting because,
good answer. I like that answer. That's a good answer.
I don't know these people. I personally, in my approach, I bend over backwards to try to give them the benefit of the doubt based on what's known at this point in time. I don't have any reason to think that they particularly are involved. I have a lot of reason to think that this was probably, this could have been an extremely traumatic experience for them. And so it's just a situation for me personally where I would rather err on the side of being cautious about, drawing any bad inferences about them. But that being said, if the defense is going to go down that road, they're going to have to be very, very careful with it, because the jury is going to be very sympathetic to these girls. And, the defense is going to have to, if they want to be persuasive with the jury, you got to lead in pace. You got to be on the same page as the jury. You guys need to be in alignment with how you're approaching people and how you're perceiving people and how you're communicating with people. And so if you're out of alignment because the jury's over here feeling bad for these people and you're attacking them, they now are out of alignment with you. They don't like you. So it's very difficult. And it's a situation where the defense is not, I wouldn't expect, going to go down that road unless they can really, really, really back it up, just because of how hard it would be to not just, blow your case looking like a total asshole to the jury. So if they have what they need to back it up, then you're back in the same situation. The facts can speak for themselves. If you have the goods, then just present the goods, and that's all you really need to do.
Perfect. I think that's well said. As far as people want to know, why would anybody ever try to keep things out? So closing out Idaho 4 talk here will be my last one, which is bushy eyebrows. Why would anybody, like, when someone's like, hey, why are you even keeping it out? Like, who cares if it's,
because nobody knows what that means. Nobody knows what that means. And that's the thing. It can mean anything to anybody, and it will mean whatever you want it to mean, depending on whether you want the perpetrator to be Brian Koberger or not. It's completely standardless. Do I have bushy eyebrows? I mean, some people would probably say I do. I don't know. Do I? Maybe I don't.
No, I mean, no,
I have, probably thicker eyebrows than your average. So like, that's the whole thing. If
Andrea, God bless you, you got the bushiest brows.
Eyebrows. If you want it to be me, you can say, yeah, she's got bushy eyebrows. If you want it not to be me, you can be like, no, she's got impeccably groomed, very, whatever.
I think they're perfectly curved right here, like not too skinny, like they just accent everything, No, I definitely wouldn't go bush with you. I would say, yeah, you're good. You're good. And then moving on to Karen Reed, which we're going to start. We're going to shake it up here. We're going to make people laugh a little.
Mm-hmm.
And I created a pick'em. Okay, I created a pick'em. So March Madness, because this case is just wild. So what I have done here is let me stop that, share this one. Whoopsies. If you guys want to join in, you just have to have your, it's like a bracket, but not really. Here it is. This is a truth and transparency, okay, for the trial. And it's Karen Reed 2.0 Pick'em Challenge, okay? So me and you are going to make our picks live in front of everybody right here. It's an over and under on the wildest stuff about this 2.0 trial. There's 50 questions, and it's either over or under. So first category is betting on the jury. So number one is the number of days that it will take to pick a jury. Is it going to be over or under 2.5? So what that means is that if you think it's going to go 3 days, you would go over, and you'd be writing, over in the pick column. And so I'm going to go with, based off of Bev's and her, what she kind of just said, I'm 100% in on right here. My pick is over. I'm going to give you a column, Andrea.
Okay.
So I'm not going to forget about Andrea's column here. I got to insert my column here. Insert. There we go. And this is, okay, I go over. What do you go?
I go over.
Ooh, Andrea, why don't you tell people what we did at Delphi? We were picking who the defense and the prosecution was going to pick. Do you remember that?
Yeah,
that was kind of like our fun little moments,
I do.
Before everything just got crazy over there. Next up, Andrea, what do you think? Number of jurors removed during trial. Do you think anybody's going to be removed during trial?
Yeah, I'm going to pick over.
You're going to go with it? Okay.
Yeah, it's just very common with a trial of this length. Things come up. Yeah, people get sick, whatever. I'm going to say over.
Perfect. Okay, number of hours that the jury deliberates. And now, just for the record, there is rules here. So let me scroll down to see what those little pluses, and that just means there is stoppage when the jury is dismissed for the day. So we don't count that, and we do have a running clock when they're in during their operating time. So with that being said, do you go over and under on 6.5 hours?
I go over.
I'm going over as well.
I think they should, but I think they will.
Okay. So now we're betting on the weather. Number 4. This is hilarious. The number of total witnesses who will mention the weather during their testimony.
I'm going to go under.
You're going under? Okay.
Yeah.
I'm going to go over. All right. We're betting now on the witnesses. So last trial, there was right around here, I think it was 73 total, 74 total. For this trial, over or under on 72.5.
Oh, my Lord.
I know, right? I'm going
to go over.
Over. Okay. Now Commonwealth witnesses, 59.5. It was, I think 67 was last trial. So, this is if you want to, I'm going to go.
I'll take over.
You're going to go over for the Commonwealth? Yeah, I'm going to go over as well. I thought that Hank would, I was, we'll get into his little strategy.
Well, he's got his new experts, like he's taken some off, but he's adding some on. And, there were these, like a few original ones that didn't get called in the first place too. He might reconsider. So. Okay.
Yeah, I like that. Let's see. Okay. Total number of defense witnesses.
I'm going over on that.
Okay. So then they're going to bring it this time?
Oh yeah.
All right. They're bringing it. I think they're going to bring the house here too as well.
They got all the experts and stuff. I'm going definitely over.
Yes. Okay. So the number of total trial days. This is just from, it has nothing to do with the jury being picked or whatever. This is opening to closing, 36 and a half.
Evidence phase. I'm taking under.
Under goes Andrea.
That's 7.5 weeks. So I'm going under.
Oh. Alan Jackson. Yeah, well, as if you were listening. Yeah, that's a good bet because Hank was trying to say that he was like, it's probably gonna be my 3.5, right? Didn't he say around there?
They came in the ballpark of like 5 to 6 on their estimates, but you always go long. So
yeah, and it's just total. Like, I mean, obviously it doesn't count days that are off or anything like that. It's actual trial days.
Oh yeah.
Okay, here we go. The total number of witnesses that say the phrase "I hit him," 5.5.
Oh boy. I'm gonna say under.
Under.
Yeah.
That's what I went with. Okay, this has been a big topic, hot topic of the number of total. They're talking about demonstratives. Like, can we use these chalks? And
chalks.
So how many? Yeah. Chalks. How many?
I'm saying under.
Chalks?
I'm saying under. Bev seems to hate them, so.
Oh yeah, Bev's like, I have something I want to say about that, Bev. Okay. Now this is betting on cross-examination. So we went ahead and took all of the defense lawyers, so Alan Jackson, Little, Yannetti, and Alessi. And what I went ahead and did is based on the number of total witnesses that we kind of ballparked it at.
Yes.
I then said, okay, Alan Jackson over under on 31.5 witnesses that he will cross-examine.
I'm saying under.
Okay. I'm going to go over. Number of witnesses Little cross-examines.
I'm going to say over.
Ooh, give her some under.
I think they're going to switch some stuff around. This one is hard for me. Where David Yannetti fits in this is hard for me. I'm going to say over. Yeah,
so like interesting. Okay.
No. No, I'm going to say under.
16.5. Okay. Do you think they're going to give more weight here to like, do you think they're playing into like Bev and how she likes people? Do you think that has anything to do with it?
No, I think they're just they're redivvying up their workflow. And so like where Ms. Little had previously been primarily in charge of the experts, I think that's going to largely get handed off to Mr. Alessi. And I think that then Mr. Jackson and Mr. Little are going to kind of, or Ms. Little are going to kind of more equalize between themselves with some of the other Commonwealth witnesses.
Oh, well then I'm going to switch mine to over here. Thank you. I'm just kidding. I can't do that now after you just given up your strategy. Yannetti, I'm going to go with over on this only because I think he is going to handle a lot of the, he handled a lot of the Canton and firefighters in the beginning. And so I think he did a chunk of people out of there. Yeah. I don't see that changing. I mean, like you've done all the work in that, but I mean, I could be wrong, but the Canton and the firefighters, I mean, right there, if he should be able to nail that. Yeah. Okay.
And so I'm taking over. I'm taking over on Mr. Alessi.
Because you're right. I think that he's going to handle all the experts.
Yeah.
Absolutely. I'm all day. All right. Here we go. We're betting on the second string here. In the number of witnesses. So this is ADA McLaughlin that she either directs or crosses, doesn't matter. She didn't speak but one witness last trial. Yeah. So what do you think here? Do you think that she's going to get a chance here?
I'll take over. Yeah, I'll take over.
Okay.
I could see that.
You could see her getting some love here. Whoopsies.
I could see her getting a couple of like, what they consider sort of throwaways or like technicals or like custodian of records.
Oh, maybe you know what? A custodian of records. I got a couple of those. I'm still gonna say under. Okay. Number of witnesses. Lally directs or crosses.
Lally, I'm taking under. I really think Lally is going to sit there with his "I've been grounded" 1,000-yard stare. I'm just here so I don't get fired. I don't think he's going to do anything.
I'm just here so I don't get fired. I love it. Totally. I went under as well. Okay, so if that's the case, well, it's still possible. Under on that one.
I'm not sure we will hear words from Lally at all. Honestly, I'm going under. Yeah.
If he just cross-examines those like 2 people though, he could totally get there. I'm gonna go over. Only because he could get it with like he could get what if anything with 1 person.
Yeah.
But I think that it makes sense to go under if you don't think that he's going to get a shake.
Yeah.
Okay, so here, Brennan's shortest direct examination of a witness. We're not counting the kids. It has to be a watched. So is it going to be over or under 12 and a half for his shortest direct examination of a witness?
Under.
I know. I'm trying to think like who would it be? Would it be like if they ask Aaron to come back on, like, Paul's wife, I got to go under as well.
My thinking is like, just even for example, like the, second, third, fourth, fifth firefighter and stuff like that. If we don't spend all the time talking about the apron and the same repetitive shit that we heard over and over and over again, the first trial, and we just actually get to the substance, it doesn't take very long. So
yeah, I mean, it should be like half of those people shouldn't be testifying. Okay. So now we're betting on the non-McAlberts. Okay, so this is, oh gosh, you know, obviously Sarah Levinson is. Well, this is the total number. She smelled one time in the trial, the first go around, talking about her shoes, and her mom made her, oh my God, you're gonna slip and fall. So she gave that little story, but will she smile with teeth 2.5? So 3 times is got to be over. What are you gonna go with? I'm gonna go under.
I'm going under.
Okay. Well, next up is Julie Nagel. The number of times Julie Nagel mentions a McAlbert in her testimony. Over all day. I'm going over as well.
Yeah.
Okay. The number of times, this is a good one. Number of times how long is said during forensic expert testimony. And what the pluses stand for is it's only expert, but if like the lawyer says like, house long, then they're in as well. So that's what that means is that this will include the question and the response by the attorneys / expert witnesses.
Oh boy.
42 and what is it at? It's 40.5.
I'm gonna say over.
I'm going over too, only because there's more.
There's more experts.
There's more experts.
And more,
That's why I'm going over. Okay, now this is a fun one for our YouTubers here. Are you planning on going to the trial?
No.
Okay, come on, Andrea. Now I'm totally going under now. Okay,
I've been gone too long already, and I'm going to be gone for August. So in August, September, October.
Oh, really? Oh, yeah. Are you going to trial? Are you going to Colburn the whole time?
Yeah.
Okay, I'll see you there. No, I won't be there the whole time, but I'll be there for 2 stints. I'm
going to say under.
Under for the total number of YouTube. Do you want to count them out in here? Okay, you're going to go under. So Andrew's going to pick under.
Yeah. It's a small courtroom.
But at any time of all those days, they all like to shuffle around. I'm going over.
Okay.
I just think that I think that there's enough locals there that I can get to half of them. And if we got some out-of-staters that come, we'll see. Okay. Yeah. Over and under on the total, the new witnesses. So from trial 1. So somebody that didn't testify in trial 1, they testify in trial 2.
Over.
11.5.
I'm going to say over.
The experts should kill it, right?
The experts. Experts make a big difference.
Yeah. So the experts. And then I think that they added some of the Canton, with the whole Sally Port crap.
Uh-huh.
All right, betting on the projector. I love a good projector. So the number of trial, the number of trial days that they use the screen to show an exhibit. So we said there was going to be
over.
You think it's happening almost every day, huh?
I think it's almost every day. Yeah.
There we go. I like it. Number of total witnesses who will view an exhibit from the projector. Then you got to be going over that.
This one I might say under.
Okay.
I got to think about this. Okay, yeah, I'm going with under. That's my first gut instinct.
Okay, I'm going with over. I got to go. If there's going to be 70 witnesses, 50 of them, I got to go with it.
I just instantly jump into like Carrie Roberts and
she was shown the video.
Well, yeah, I guess she was. Yeah, she was.
You want to go over?
Ring video.
Yeah.
No, I'll leave it. I took my
Okay, you
pick. I'll
sure?
leave it.
Are
Yeah.
you sure? Okay, watch that be the winner. Okay, betting on the locals. So the number of total minutes that
Okay.
Sergeant Lang, he was the longest person to take the stand that was like a law enforcement outside of Proctor. So I didn't know what would the parameters would be with Proctor. So again, this is total minutes. If it breaks for the day, you know, he has to be on the stand. Objections count, sidebars, it still rolls. But if there was like a break in terms of, hey, he came on at the end of the day, you know what I mean? Like we don't run the clock during the night, stuff like that. So that's 140 minutes over under. Void year would count.
Over 2 hours. I'll take over.
Okay. Total number of minutes for, now this is a newbie here. Helena Rafferty, Chief.
I'm going under.
I'm going under too. I mean, unless Ellen Jackson, then we're going to go, you know what, I'm going to go over. I think Ellen Jackson might try to stick her. Number of total Canton police officers and firefighters combined to testify.
Over.
Over?
Over.
All day.
Yeah.
Number of different Canton police officers, firefighters shown a report to recall their memory.
Yeah, I'll go over.
Like, it's been a long time, right? Oh, God.
Yeah.
Number of different Canton officers who testify about a leaf blower.
Over.
Over. You know how much? There was 3 of them there, right? That were
3 of them there, and then others who talked about the fact that it happened. So.
Okay, yeah, there you go. The number of different law enforcement / firefighters who are asked about John O'Keefe's cell phone.
It should be. It should be over. It should be freaking every single one of them who was there.
Right. So you going over?
Yeah, I'll go over.
Yeah, I think that they're gonna. Yeah. Oh, here we go. Number of times Trooper Proctor cusses on the stand.
Now is this voluntarily or is this reading his text?
Yeah, this is if he says a cuss word, man, it's on. I'm
gonna say under.
Under?
Okay. He's gonna try to avoid it. He's gonna do everything he can to avoid it. So I'll say under.
Okay. So Andrew's gonna go under there.
I think Alan Jackson might say it a lot, but
I know that needs a change. And then here's the last couple categories, which is betting on the opening and closing. And that is the total number of objections during opening statement. Do you think
I'm taking over because
me too.
I think that Mr. Brennan is exactly the kind of dickhead prosecutor that will object during opening.
Yep, I agree. And he already kind of made it known. He was like, they said something in opening and they weren't.
Yeah.
Yep,
I'm going to take over on closings too.
Oh, yep. He's going to interject.
Well, on the defense will too, because he's gonna be objectionable. I think the defense will object during closing.
Oh gosh, Andrea, you're making me. I felt like if I did the over, I was like, you gave me a hint. I think that I just know that I think Brennan's gonna do it on the opening.
Yeah.
Because if they say she was framed and object. He's gonna lose it. He's gonna lose his shit.
Well, he's gonna try and nitpick and all that stuff. So yeah, I expect that. So number of times it says defendant 11.5. I'll say over.
Yep. And then pick, I'm gonna go as well. Proctor, if they say the number of times that they say Proctor in the opening.
I'm gonna say under. I don't think they're gonna necessarily make it about Proctor. But we'll see.
Fired. I think that they're going to say his name. I just don't know if it's going to be more than 7.5.
Yeah, exactly. Well, that's what I'm thinking. It's the hammering on it and emphasizing it. I don't think they'll do.
Yeah, especially if they go hard at Higgins. Okay, here's the Bev categories, which I just love, and we're coming to close here. So the total number of sidebars, regardless of who calls them.
Over. It's going to have to be
3 a day. You get to it.
Yeah, it's going to have to be. If she's not letting them state objections, it has to be. Number of trial days she has her hair up. Under.
What do you think about that one? I'm going over. Come on, she's got to use a scrunchie a couple times, Andrea.
I don't know. I know they're trying to bring the scrunchie back, but it just hasn't necessarily landed yet. And she is.
She's
You know,
2 days.
she's got her thing down.
This is my favorite Bev, betting on Bev all day. All my money's on Bev. Number of total trial days. Bev starts later than 9/12.
Now, does this mean that court is called into session, or does this mean that evidence starts being in?
No, this is her being like, Bev walks in.
They come in and they have to have a sidebar. We have to immediately talk about something, that kind of thing.
Oh, well, this is when all rise.
Oh, all rise later than 9/12. I'm going to take under.
Okay. God, you gave her a lot of credit there. Okay. So Andrea goes under. I'm all day over. Bev is on her own schedule. Bev's like, I need my weekends. Okay. So, we're betting on the McAlberts with a side of Higgins. So
yeah.
I want to make sure that this is clear. Like, I don't remember. I don't recall. Okay.
Yeah.
So Colin Albert, it's all he kind of said. Do you think he's going to say, I don't recall, I don't remember, over under 23 and a half times?
Over.
All day at the house. Number of times D&E is said during Chris Albert's testimony. 2.5. So
over.
I was like under just because I don't know why. Like, oh shit. Jen McCabe looks at the jury.
Over.
Like every other question, right?
Yeah. She did that Amber Heard thing, just constantly, doing the explain to the jury. And then also like when they're at sidebar, she'd like peek at him and stuff.
She's just like this. She's looking at him. I swear they better not move that camera up so I can get all my my bets in here. Okay, total minutes for Jen McCabe on the stand, 280.
Whew. That is not quite 5 hours.
What do you think?
I'm going to say under.
Okay, Andrew's going to go under. Gosh, they had her on the day. She was there for 2 days. Did she come back the third day?
Yeah, she was on for a long time.
Yeah, I mean, this trial, I just feel like they're just going to, like, maybe not, but I'm going to yeah, let's fuck it. Number of times Jen McCabe says her name, Jen, in third person. Me too, because she says them in threes and she's going to do it twice. Yeah. That's why it's like all day. Oh, shit. Okay, here's a good one. Number of times any McAlberkins, so that's plus Higgins, says butt dial. So if they say butt dial, it has to be a McAlbert plus either one of those people.
I'm going to say under. I think the attorneys are going to say it more than they do.
It was a butt dial. What was it? What would you call that? But I'm going to go, I think each one of them is going to say, so if I give Jen one, Higgins one, and Brian Albert one, and then, God, yeah, I mean, even if they say it twice, they'd have to say it 3 times each. Who else had a butt dial?
Nicole had butt dials.
Yeah, I'm going to go under. I like that. Okay, now, Brian Albert had a problem with saying Chloe last trial. He was referring to drugs and it. So, what do you think?
I think over.
Yep. And the last category is betting on the newbies. Do you think Paul O'Keefe, that he was not cross-examined last time, is he going to be cross-examined this time?
Yes.
Okay, so you're going to go over.
He sued Karen Reed. He's got to be cross-examined on bias.
Okay, perfect. Total minutes. Turtle Boy is on the stand. Do you think he's going to get called?
Under.
You don't think he's going to get called?
No, I think that would be absolutely foolish on Mr. Brennan's part.
I have to put it. Even though they got the text in the
I don't know if they're going to get anything that's meaningful or helpful.
I almost feel like he just is going to call him only for the sake of keeping him out of the courtroom, making it so that I didn't try to ruin his livelihood with not having him sequestered and not being able to talk on what do you think about that?
I don't think he cares. I think he can have him out of the courtroom and never call him on the stand, and
he
then
doesn't give 2 shits.
Yeah, it wouldn't. Yeah, I don't think he would care at all.
Okay. What about Carrie Roberts? She wasn't cross-examined last time. Do you think today or this trial is the day?
Yeah, I think over.
Yeah, me too. I think they have no choice. They didn't find out
Yeah.
about the phone. And then they put her dad on the ticket.
The witness list.
Yeah. What do you think? Do you think he's going to take the stand at all?
I'm going to say yeah, because I think they're trying to paint this whole consciousness of guilt, and you called your dad, so I think they might call Bill.
Yep. And so here we go, Andrea. We are printing it off, and it's official print. You win, girl. All right. So talking about the Karen Reed case, we'll close this out because I said I'm only going to keep it for an hour and a half. We've been here for an hour and 50 minutes. What are your biggest takeaways from the motion limines as far as big wins for either side? Not too concerned.
Oh man, I mean, God, it's just been such a flurry of stuff that's been happening in that case too, and in the lead up to trial. I think the real meat with the motions, the pretrial motions this time is really with the experts, because that I think is going to play so much of a bigger role in this particular case. Obviously, we know there are more of them. Everybody's kind of doubling down on having experts and being able to get people in and stuff like that. So I think that, like, the ruling on stuff like Welcher is potentially pretty significant. The ruling on Crosby, pretty significant, because these are just, from my perspective, those are very marginal witnesses and probably should have to go through some kind of Daubert-Lanigan qualification. We know that with Dr. Crosby, she did not require that. And so with Dr. Welcher, is she going to do it? I don't know.
So how do I want to say this? Okay, so they've kind of agreed that it's not going to be a mystery about the ARCA guys. Do you think that could be like kind of like the end all be all
with ARCA?
Yeah, like knowing if they know that if the jurors were told and they know, hey, this is from a federal investigation, not Karen Reed's insurance company or something.
Yeah, honestly, I am very, very sympathetic to the defense's desire to make this clear. But I have to be frank. If I'm the Commonwealth, I don't necessarily mind the jury hearing, because they're very likely to conclude that the feds are investigating Karen Reed. They're not necessarily thinking that there's like some whole other federal investigation that's going on. And
True,
so
I never thought about it like that. That's a great way to think about it.
That could have the potential of suggesting, if like the FBI is involved, then maybe the investigation isn't this absolute flaming dumpster fire that we can otherwise, it otherwise looks like when we look at it with our own eyes. Maybe it actually gives it some weight and credibility if the FBI is involved. So to me, if I'm the Commonwealth, I think this is a pretty good compromise.
Like to say that, hey, we were put. Okay. I my take is I don't want the jury to be misled. So like we should just be laying it all out here and just be honest about whatever it is, however they got involved. I think that if it was Karen Reed's team going out and saying, hey man, they're just doing all this stuff and you're never going to believe this, then let it come out that, yeah, we looked into it and we didn't, obviously we didn't indict anybody, but whatever it may be. But is that even like, I think it's like really this case is like a soap opera.
Nobody's going to be able to testify to that. Who's going to be able to testify to that? They don't have
Josh
a federal witness, as a witness. Hank is the prosecutor. He can't testify. Is Chief Rafferty supposed to get in there and testify about this phone call she got? No, that's hearsay. It's not admissible anyway. So they don't have knowledge of the FBI investigation. That's the whole point of like what he's saying. He's trying to say, well, I have all these questions, and so therefore I should like be able to present them to the jury as a thing. But that's not the case. I don't see the line of reasoning that if you mention the FBI, that now you necessarily have to open the door to the whole context, because the reality is you don't know what the whole context is anyway. So
you don't.
I think I think, frankly, I think Bev is probably going to just keep it like she did last time. She's going to say, no, you can talk about another proceeding or something like that, another process. But I don't think she's going to allow him to mention the DOJ. But honestly, like if she did, I don't know that that's necessarily like the best thing for Karen Read.
Do you think that you would, if you're obviously a defense attorney like you are, would you be like already prepared like for, let's say, all right, hey, did Karen Read's insurance company hire you? Would you just start rattling off all of these things to make it perfectly clear to the jury that?
I mean, if you can, you try to rule it out, but how do you rule out the whole, like, you never know what the jury is going to come up with.
Okay.
It's hard to foresee,
Do you just leave it as like, we hired you? Who gives
especially
a
if they
shit?
don't like you, they may just think you're being tricky. They may be like, oh, well, Karen Read didn't hire her, but maybe her dad hired him. And so it's just, we're just like avoiding, it's so motivational. So,
That's so
I
true.
think that that the FBI is really a pretty good compromise.
Okay. So the next topic in the Karen Read case is, do you think that all of these documentaries and whatever hurt, not hurt, indifferent Karen Read?
Well, I mean, after the motion we got today, it might hurt. It might hurt. And the reason why, I don't know if you saw the motion that came out today, Hank is arguing that she has explicitly waived attorney-client privilege because of certain communications that she related them in some of these interviews. And what I mean by that is that she said, I told David Yannetti this, David Yannetti told me that. That's like, I got to say, it's about as clear a situation of a waiver as you get. You have to keep your conversations with your attorney confidential. They are a secret, but you have to keep the secret. And if you don't keep the secret, then you don't get to keep saying, you don't get the protections of it being a secret. So she didn't keep the secret. And I think that has the potential to be, to be problematic, to potentially open doors and create some procedural problems for her.
What the? I didn't see that motion. No, I saw the Turtle Boy and Karen Read text can be, whatever they're in that was ruled on.
This just came out. This just came out this morning. It kind of blew up today. It's what I was really focused on today, and instead of getting caught up on Cobra, running down this rabbit hole of the confidentiality. I mean, it's a big deal.
So this is a huge thing then, because well, I see this kind of goes back to my thing. I'm a huge person of our Constitution. I'm a huge person of like, dude, we have these rights for a reason. You have the right to remain silent. I'm telling you, that's so powerful. Don't say anything. Yeah. Okay. Like, dude, you ask me how my day is, ask my lawyer. Like, I have nothing to say to you. I've learned it. And I'm like, dude, you guys twist things, get FUC. But so I'm like, God, why? Like, you have this powerful team and they're doing such a good job. And but then you have people that are over there like, well, if you're so innocent, then you would just be screaming from the rooftops. I'm so innocent. I'm like,
it's true. No, I mean, it's true. Like, that's the thing. Like, I understand these are the things that she's having to weigh, the fact that it's held against her kind of no matter what she does. If she doesn't speak, then it's going to be like, well, you're guilty, or you go tell everybody you're innocent. If she does speak, then she's going to get picked apart. You're trying to try your case in the press instead of in the court, and so forth. There's like really no way to win. It's already also like tied in, for better or for worse, with the fact that this is an extremely expensive process. She is dependent on people supporting her and her defense fund for her to be able to defend herself. And so it is important for her to kind of keep her case in the profile, in the high profile, and making sure that her side is being heard. So I don't envy the position that she's in, and I think I understand what some of the motivations are. And that's just beyond the fact that if you are innocent, you do want to say that, I definitely get that. So it's just unfortunate because there are so many pitfalls when you choose to do that. And yeah, it can be very easy to make mistakes.
What do you think about, is there any truth in the matter that ID went and aired something when they were asked, hey, can you please not air that?
I have no idea. I don't know.
Yeah, that's what I said too. I was like,
you know, from a timing standpoint, I guess the question is like, do they get more bang for it now, or would they get more bang for it like once the trial is underway? Like, you know, if they were really trying to like maximize, you know, we want people watching, it would make sense to do it on like, you know, week 4 of the trial or something like that. But then you're really in the realm of, you know, risking interfering. Although, you know, technically the jury, of course, isn't supposed to be watching any of this stuff. So now is when you would release it if you want to have like the maximum impact on the jury, on the potential jury pool. So different thought processes. I don't know what they're thinking. I don't know what their process was, but the timing is definitely not great. I mean, for either side, it's just not great.
Yeah. Bev said like, hey, we're going forward. It's April 1st. Like I don't care what's happening in the appeals. Like we're plowing. So then that brings me to this question, which would be, okay. I look at it as I'm a very like timeline, but also like, come on, common sense logic here. The Commonwealth does not know where their victim was from 12:30 to 6 o'clock because their own witnesses are saying he wasn't on the lawn. Mm-hmm. Why aren't we pounding that to say, stop trying to discredit these people and just say everybody is saying he's not there. Mm-hmm. Okay. Like, he's not there. Mm-hmm. Instead of
we're trying to blame it on the snow. You know, they're trying to blame it on the snow. And so that's where I think this is why I love Mr. Alessi's addition to the team, because my observation of Robert Alessi so far, he is one of these, he is a meticulous detail person like us. And so, yes. And he's very, very good at organizing it and communicating it in a clear and systematic kind of way. And so that's where the details about this matter, the being able to put it together. Here's all the people that said they didn't see him when they left. Here's the timeline. Here's what we know about the conditions at that particular point in time. And, you know, potentially being able to recreate that so that you can really lay it out explicitly to the jury. Okay, at this point in time, 2 inches of snow might have fallen. And if John O'Keefe was lying out there on the lawn and he's alive, right? He's body temperature, snow's going to hit him. It's going to melt initially. And here's like what that process is going to entail. If they can like really work through that and just demonstrate this story doesn't work. So there was a man in the lawn under the Commonwealth's theory that nobody saw. And now you're going to be able to go to the scene. You're going to be able to see it. And here's what the lights, going by would have looked like. Like you just got to show the jury as much as you can what this would actually look like. And by doing that, you can demonstrate how infeasible that would be. Yeah. I mean, I've been there. This lawn is so small, Andrea. Like it is, it's nothing that it looks like on like photos. Yeah, that's what I've heard. That like you just get. That's why he doesn't want the car there from the photos. He doesn't want the car there because it will show that, wow, if you're talking about an F-150 there and a Jeep there, there's no where these cars are on each other. Yeah. So the other thing another thing that I did, and people were like, oh my God, why are you're releasing something that's going to hurt? I did the whole timeline of Karen Reed's phone and her watch and showed that, wait a second, she doesn't have her phone when the house on a die was Googled, but she also doesn't have it when it was Googled in the morning at 6:23 or 22. Mm-hmm. Because the phone is moving before the watch is moving, like in at different times, but also it's not going up and down. It's not going upstairs when the watch is going upstairs. Yeah. The phone's not going with it. And so I put out this whole thing and I said, Matt had it, which that was a good insight. Yeah. How the phone and the watch don't correspond. Yeah. That was very, very good. And I think that why I think that they should consider it and look into it is because Matt chose not to go with Carrie Roberts and Jen and Karen
what guy wouldn't he would usually, hey, I'm going to drive. Let's go. Like, we're going to go look for John or whatever.
Mm-hmm.
He's saying that he's waking up in his bed. He did not, but and that she's supposedly drunk. Why would I ever let my significant other go and ride in a car with somebody who's a crazy person and drunk because she woke up drunk, basically?
Well, that's what they're saying, right? They're saying she shows up at the hospital later that morning and blows a .0. And it doesn't blow, but the blood. She's like, they're trying to say she's like, they had .08. So.
And so when you actually like look at, I'll send it to you. It's a graph, and it shows that, let me think. I think I may have it right here. I can just pull it up. Oh yeah, here it is. Jen's iPhone iWatch steps. Okay. Here you go. I'll just put on the screen so you can see how this happened. Oh, wrong one.
But I think kind of along those same lines too is one of the things that came out recently that caught my attention was the new report from Tully, right, about the meeting that he had with Jen McCabe and apparently Matt McCabe. And one of the things, because Jen had testified it was her and Allie, but the report that we get from Tully, it's her and Matt. And one of the things that he shows them is dash cam or body cam or whatever of Matt at the scene. We never heard any testimony about Matt at the scene. Matt wasn't supposed to be at the scene. So where's this body cam? When did that happen? Like, this just opened up a whole new bunch of questions for me about Matt McCabe's whereabouts.
That's why I did it. Yes, exactly. So then this is what I did. And here you go. It's like, wait a second. When you want to compare, and if I can move this over this way. So, and I was able to isolate and show that, like, I don't think people realize this, but the phone, the phone doesn't move from 12:19 until 12:41. But here, the watch is making all these steps. So I have them side by side here. Can you see?
Yeah.
And then something that I think is interesting is when you do it, like when you get down to the nitty gritty down here. So here, the phone it stops moving at 12:43. She's doing all these steps and all with her watch all over. But then here, what's interesting is that when they supposedly arrive, which is in between this time frame at the residence at 34 Fairview at 12:18 and some seconds, 50 seconds, the phone call that John makes to her, she said it was on Bluetooth. Okay. If my phone is on Bluetooth, but I start to walk, so here's my watch, right? And so you see, like, I'm leaving the waterfall, making my steps there. Then I walk around the car. I get in the car. So then I'm driving, and then I get out of the car at 12:18 and 50 seconds. My watch starts moving. And do you see how this ending at 12:19 and 22, when it's always more accurate with the watch. But it matters of when the call ended with John. And what you're able to see is that the phone stayed in the vehicle because it was being utilized in Bluetooth. And she's over here and left the car. She left the car. And so she's walking and she goes into the house and takes 50 or 49 steps. The phone stays isolated in the car. Okay. And so it stays in the vehicle when everyone's like, oh, I had it plugged in, right? I call bullshit on that. Because unless we were to see Matt's, but look at this, it doesn't move again. So when she's saying I was standing up and I was getting up and I was going over to the door, right? And I was looking through. So let me pull this up. So we're going to take us out of the equation for a second. I want you to see this.
Because she's got all the calls to John during then too. Is she doing that from her watch?
Well, so this is great. When she's saying, though, check this out. She says, look at this, 12:19. Do you see that? She doesn't move from, 12:25. So what it looks like to me is that she goes out, runs in, and then she comes back to her vehicle. Okay. And that SUV leaves, and they actually go somewhere. There would be like a 5-minute drive somewhere and a 5-minute drive back, because here she does not move from 12:25 until 12:35. She nor the phone is moving. If she's standing at a party, look at this. She does not move from 12:25 to 12:35. She is stationary. Is she on the toilet taking a shit? What is she doing? She's not moving, and she has this watch on, nor is the phone moving. And so what it's indicative to me is that, you know how she says that Allie gave, Colin a ride and stuff like that?
Yeah.
I question that a little bit, but I can show you that she's definitely stationary. She didn't take the watch off or anything like that. And then what's interesting is that after she's stationary at 12:30, see 12:35 and 39 seconds?
Yeah.
She starts moving and walking from 12:35 until 12:45 and 02 seconds. She does all these steps between 12:35. You see 12:41? You see that? Like she's making at least 6 steps before I realized that my phone's outside, right? Oh God, I gotta get remember how then what they testified that she plugged it in?
Yeah.
She realized that it was outside. So she has to walk out from being outside to go to her SUV, then grab the phone and walks in. And if you take the 16 steps there in between that time, which was very short, plugs it in. And then look at this, ready? This is not indicative of somebody at 12:25. If you're walking around a party and hanging out, you face plant or you do something that you're not moving for that time. It's indicative of you being in a car, because after that, at 12:48, well, first of all, 12:35, you're walking around, then you're stationary for 3 minutes. But then here you're walking all over like you would at any type of a party. And this is where I believe when Sarah Nagel or Julie Nagel and Sarah Levinson talk about, they came in. Yeah. This is where I believe that everybody came into the party. And that's why I believe John O'Keefe in this moment up and through this section is when he was walking up to get to that door, as that he was confronted. He never went in. There was an altercation right there, or they were like, hey, jump in the SUV because we're going over to so-and-so's to grab so-and-so. And that's why that he had called and was like, because why wouldn't you just, when you're like, when he says where to, what? I just talked to you on the phone. Like, what do you mean where to? Like, we're going to Brian's. Like, you would have said, what's Brian's address versus saying where to, in my opinion. And then the other thing that's just bombshell right here is, so here she's moving. This is all with her watch on the left. Yeah. And nothing happens until right here. 1:34 and 2 seconds, right? 1:34 and 3 seconds. So the iPhone and the phone look like they're moving together, right? Okay. See? Okay. Yeah. And then, and then so she's walking around with her, here's her watch. It stops at 1:43. See 1:44? See that? So it's like she goes to the SUV here at 1:43, and then she is in the car. She probably plugged her phone in the car back then in it. But then she clearly maybe stepped out of the vehicle because she's still taking some steps. But look at that, 302 between 1:36 and 1:44. So then I thought about that. And you know what I do when I can't find my phone, Andrea? I run all over. I'm trying to find my phone. So here, when I'm thinking that she's moving with the watch moving, what it looks like is that she either doesn't realize that the phone's in her jacket that she put on, or Matt and her begin to move at the same time because it's in his jacket. And they go out to the car together, but she's off running around because look at 35 steps, Andrea, in the time frame. Look at 35. She's taking 8 and 30 and 302 without the phone during the same time. So she doesn't have the phone. Do you see that? Yeah. Yeah. And so and that's where I was like, damn it, this motherfucker went outside and started the vehicle. Okay. And probably carried her jacket. I don't know, maybe carrying her because she's so drunk. Who knows? But then I was like, wait a second, but she's walking. So I had to cross off that. Like I was eliminating things. At the end of the day, they get into the vehicle. Look at though. This is to me that shows me everything I need to know about everything. That man, Matt had her phone because here they're in a vehicle and they're about to drive away at this time. They're already in it at 1:47. They drive away. Why would her phone, while they're driving to take people home, how does the phone move and the watch not move during the drive? It's because he got out of the car to do something for 2 minutes. And that's where I believe that they went, if they were truly passing by over where Karen Reed or, John lives or whatever, but it shows me that He moved without her moving, and he got out of the vehicle while it was moving to like stop. So could that be over by where the body? I mean, but it shows me that the phone and the watch aren't like you're moving.
Yeah,
the phone
they're not in
and it's
sync.
not the watch. Yeah, it's not the watch user. You know, it's not the owner. Then they get out of the vehicle when they finally get home at 2:13, and this is where I said, "Wow, check this out."
Yeah.
Ready for the flight of
Phone's
stairs?
not moving at all, but Jen is still pacing around with the watch.
Yeah, because he hid the phone. When he got home, he put the phone into a drawer because I think he told her, "We'll just get the phone tomorrow. Who cares?"
Yeah.
You know, like she couldn't find it at her sister's. Okay, let's go. We gotta go. Let's go. We'll find it tomorrow because he took it. Because guess what he then ends up doing? So she goes up a flight of stairs, right here at 2:21. Because if I pull up the flights, then she goes up a flight of stairs with her watch on, and the phone doesn't go. And then literally right here, these 19
Cost long to
steps,
die in cold.
it happens during this time frame, 2:23 to 2:31, and it's after she went upstairs, and he took this. See how it's 2:22 to that.
Mm-hmm.
He then is moving after she goes upstairs. He goes to grab the phone out of like the drawer, and from 2:23, and you can see she's not moving. See how it goes at 2:31. See how her steps don't start until 2:32 after she just goes up the flight of stairs during that time period.
Mm-hmm.
He is walking around, only takes 19 steps. This is when all the Googling happens between 2:23 and 2:31. And I turned this over to them and I said, you guys, Matt did all of this. Matt did it. Matt did the Googling because you can't, because she's upstairs. And I was just like, please, will you look at this? I'm telling you, he used her phone for a reason because they never thought in a million thousand years that her phone would be taken. And then to show that it's 100% true is she gets up to wondering why isn't he upstairs? You know what I mean? He's still downstairs. So that's that movement. And then at 3:50, she gets up to go to the bathroom. So she 24 steps. But then here, look at this right there. Why would the phone ever move before the watch wearer would move? 4:55 in 7 seconds to 5:01.
Yeah. The phone.
The watch wearer didn't exactly.
Yeah.
And I was like, and that's during the time frame at 4:55.
Yeah.
Guess who gets called? Julie, Chris's wife.
Okay.
That's that big phone call.
Yeah. That's the one where she originally said she found out. That's how she found out John died.
Yes, and that's you see who he has the phone downstairs on the first level. And if you look, she just gets up and then see how she doesn't move again from 5:01 to 5:26? See that?
Yeah.
Well, guess what? Here, neither does this. But she takes this movement without the phone because she has to go downstairs to go get the phone. And this is when she begins her bullshit. And then finally, for the first time ever, does the phone go up a flight of stairs. Right here is the first time that the phone and the watch go together upstairs.
Interesting.
Oh, yeah. I blew it all up.
Yeah.
And I'm like, you guys can say whatever you want, but Matt McCabe. And then the same thing is true. Andrea, check this out. When you go and you scroll down, I don't know if you're interested in any of this, but when you scroll down right here, this is your time frame that. So here, the big Google searches. So here she is with the watch. So 6:12 to 6:17, she's doing those steps. But you see how from 6:17 to 6:26, she does not move. She's in the back of a cop car. Well, guess where her phone is? Guess where her phone is?
Where?
With her husband who showed up and took it from her. And then that's when all the Googling happens at 6:22 and 6:23. And at 6:23, that's when Brian Albert is called. Brian Albert wasn't at that house because he left. And that's why the sister gave her the number. Hey, call Brian. He's not here. And neither is Chloe. Here's the number. He's not here.
Interesting. Interesting.
So, yes. And that's why. And so it's so from 6:17 and 50 seconds to 6:26, she's not moving.
Yeah.
And then
she's
she
in the
passes off. Yeah. She passes off the phone to her husband. Okay. He starts moving with it. And that's why he asked Tully to see the damn body cam because he wanted to see where he could have been seen to see if he's on, to say why he would have been there.
Yeah.
Yep.
That's good.
I solved the case, baby girl.
That's good.
Sign me up, baby girl.
That's not alignment for sure. That's some good stuff.
Oh, and then ready for the icing?
Okay.
As soon as your birthday, I'm going to ice you up. Remember how she goes inside to get her sister?
Uh-huh.
Okay, well, guess what? When that happens, she makes a phone call. Matt does it, but to make it seem like she called me over to the house, that's why I came over. Oh, we found John here. Well, it was a 19-second phone call. And after the phone calls ended, 10 seconds later is this movement right here.
Yeah, the watch starts moving.
So she goes upstairs and gets a flight of stairs. Guess what doesn't happen with it? The phone doesn't register, just like at the house when she went upstairs for the night. Yeah, so the phone doesn't register the flight. Only the watch does. And that's right in here. And it's because, and I was like, wait a second, but she just had it because she supposedly called Matt. And so you would have had your phone on you because your next literally 10 steps goes up the flight of stairs. And the only thing that goes up the flight of stairs is the watch. And I was like, see, boom, look at this. Right here. She's moving 6:27 to 6:28. See, phone's not moving.
Yeah.
Okay.
Yeah.
Then 6:28, she starts moving again. 190 steps. This is when she begins to go to walk in, like to go from outside to inside. And when she's going to go up a flight of stairs is in between this. Okay. And look at 170. And it's this time though, it's 4.5 minutes later because she had passed it off. And then, and I'm just like, you sick son of a bitches. And I was like, people gave me such a hard time online. And I was like, I don't give a shit what they're saying happened. I'm telling you, this is the truth because the data don't lie. Every time that house law to die was Googled, Matt had the phone.
That's interesting. Yeah, no, if they don't line up, they got to explain that. That's a great discrepancy to dig into.
Yeah. So I was just like, I want to know what Andrea thinks about this. As a lawyer, would you be like, this is junk science? Or would you say, no, this is a problem?
Well, as a lawyer, I have to have an expert testify to it. So I would take it to my cell phone person and be like, does this make sense? Can you explain this? Consistent with the same person having both the watch and the iPhone. Can this be explained by like different, functionalities or different reliabilities of the different, mechanisms in the watch versus in the phone and et cetera. Cause they're not exactly the same, right? It's different hardware, different software. Does any of that make sense? Can that explain it? And I would see what my expert says.
Yeah.
That's what I do as a lawyer.
Like if somebody brought this to you, there's no way that you'd be like, you would not do anything with it.
Oh no, that's worth following up on for sure.
Yeah. Yeah. That's what I said. I was like, listen,
100%.
I'm providing you, I did the research here. I put it all together, do what you want with it. But I think that you'd be a fool not to have somebody look at that.
Yeah. No, I agree. I think that's a big enough discrepancy that's worth taking a look, and especially because it's around the time of these rather critical events that there are these discrepancies. Like, of course, you want to dig into that.
Yeah, because guess what he's saying? My whole point was behind it is because Matt was in bed saying that he was in bed listening to and disparaging Karen Reed being a psycho. Like, yeah, she's calling and saying, Chad, I woke up to Chad.
Yeah,
bitch, you didn't wake up to shit. You were downstairs. You weren't in bed, and I can prove it with this. With you're walking around with her phone that's on the first level because that phone never went upstairs until after 5:38 a.m. So now explain to me how you woke up to a 4:53 call in bed. No, you didn't. That phone was downstairs. So if you woke up to that phone, you were downstairs with that phone. You weren't in bed laying in there thinking that your kids were like coming in. All that I just think this is impeachment material to say, like you weren't in bed. But I don't know how to, as a lawyer, you would be like, okay, how can we introduce this even to?
Yeah, you gotta get in through the expert. You got to get in through the cell phone person.
Okay, well, I've kept you here way longer than I was supposed to. So, what do you want to say about anything else that we've talked about? Stacey Aldridge, you got some awesome information out of her. What do you think?
Yeah, we had a good conversation with Stacy. Some new information about like the water damage, the fact that there was more follow up she could have done with the water damage, but it hadn't been presented to her as something really to look at, which is also and it's unfortunate that these things happen. It's kind of natural that you can't cover every base, but you really do hope that gets minimized. A little bit, I think, of clarification about things like the tower, the role the tower could have had in the connectivity problems, but the fact that you would expect the tower to, AT&T would know about that from the pings, like that would be known information. So the fact that that's not known could be indicative of something more significant. And then just her, observation of the video. Like I said, I'm trying to make sense out of this video and how that aligns with what I saw in court, what was represented to me, what everybody else saw, and her description, is, again, I think if you listen to it, it doesn't sound like what is out there. And
her notes were very like,
she said, all I can hear was hey you. And,
hey guys.
Yeah, hey guys.
Yeah.
And she wrote it down. And so it's very troubling. There's really a million questions about this. And so I am, crossing my fingers that at some point soon, the actual trial exhibits that are public record and should be publicly available will in fact be released so that everybody can look at these items for themselves and see what we saw.
Yeah. Yeah. Did you hear the same thing that we heard? You're going to be able to give a thumb drive and they're going to put it on it. You just have to go to Delphi to get it.
Yeah, it's in her letter, I think.
Okay. If you need one, we live close. So versus we'll get yours. You know what I'm saying?
Okay.
We'll make sure that she's telling people that they have to come in person. So
yeah,
we'll get you a thumb drive and then we can, FedEx it.
Okay.
You know what I'm trying to say? Like, don't.
That. Yeah. I'll stay in touch if that's a road I go down. Honestly, I might wait for the Court of Appeals. Once they get sent up there, it might just be less of a hassle. I don't know. So
really? Okay, cool.
Yeah.
Well, Andrea, I think the world of you. What I saw you and Lawyer Lee do in Delphi every day, waking up, standing in line, even you guys even had lines, but you still got out there. You weren't expecting that, and people, I think they showed like that's what humans are supposed to do for other people. But you guys are authentic, and I just want to say thank you so much because I'm not going to lie to you. I've had some horrible experiences with attorneys, and someone like you is somebody that I'd be like, okay, I would not go pro se and go with Andrea. Otherwise I'm pro se. Because I'd rather just die on my own sword than, people aren't even working. Like, geez, can you just not be lazy? Like, I'm giving you the material, man. Come on.
Yeah.
So you and Lawyer Lee restored my faith in like, hey, you just got to find the right ones, right?
Yeah. Well, I appreciate that. And like you said, I am eternally grateful to the line sitters. I, owe them a debt for that, you can't ever repay something like that. It was really magical that happened and very meaningful. And that will stick with me for a very long time.
Yeah.
Could not have done that without them. So.
And we shouldn't have had to though. Like,
yeah, I agree.
You know
but
what I mean?
Nevertheless,
tell Jeff we said hello.
Will do.
Much love, but we got to do this again. I can repay it. Come on your channel. I feel like you went on a tour this week, so I
did go on a tour this week a bit. Yeah.
Did you? I knew it. I was like, I feel like Andrea just toured. But you're awesome, and so thank you so much for coming on and agreeing to come on here. So I appreciate it.
Thanks, Lana. It's my pleasure, and it's really good to see you again.
Okay, you too, hon.
Take care.
All right, hey, happy birthday.
Thank you.
Cheers.
Happy birthday to you too.
All right, bye, Andrea.
See ya.
She's you guys. I go pro se every day. Andrea, I'd ride with you though. Thank you guys so much. Have the best weekend, everybody. Yep. I want to thank Nikki. Thank you so much, Nikki. Andrew, Emily, thank you. Oh, happy birthday, ladies. Yes, it was her birthday too. Thank you for that. It was my birthday. If it was my birthday, we'd be talking about Brian Kober. Well, we talked about Brian a little bit. Why can't each juror have their own form? I wish you do. You have your own form. You do. I just think that it's easy to get pushed around in there. That's what I think. Moon. Oh, 5 membership. Senior Frogs. $20. Thank you so much. Woo. Carson. 2 smartest ladies on YouTube. Shit, I'll take that. Andrea, did you see that Hank submitted a motion today to compel Yannetti and Karen Reed's texts and emails? Yep, she did. I didn't even know that existed. Damn, what is Karen Reed doing? God, what is Karen Reed doing? Woo! What are the chances her defense attorneys get called by Hanky as witnesses? Him adding them to his witness list is crazy. They already, I think they added them to themselves, but remember for 6 months. Woo! What's up, young black? What's up, girl? What other phone watches people went up or down stairs like John O'Keefe? Nope, not hers. But yeah, if they would have just allowed everybody to get the phones, but they didn't at the time. God. I know that I'm right on this one. People lie, data doesn't. Lana and Andrea is the power brain duo that these treat. Yeah. Dude, I'm telling you, I would research a case that Andrea was lead attorney on any day. I think like anything, you got to like vibe with somebody, you got to trust somebody. And I would work until I found whatever the person that I was working for or with needed. Or I would tell them like, listen, dude, I went through all of this shit. It's just not there. I can't find it. You know, I was listening to Andrea's interview with Stacy, and the one thing that really broke my heart, because I've done it in the Moore Drake case, for Stacy to say that she just got on the case in August and the trial was in October. I just don't think that's enough time. That's just to think that you're handing a case over to somebody in August for a trial that starts in October. But then also to hear that Cecil didn't get his report over to them until August, that's just sick. Kentucky won tonight, Lana. Yay! Did they win by more than 11.5 points? My suspect was before I saw your spreadsheet. I meant up down at Albert's. I think not everyone had one. Oh, my super chat was before I saw your spreadsheet. I meant up down at Albert's. Oh, I think not everyone's phones watches were examined. Yeah, that they weren't. That was hidden. Yeah, the jury questionnaire came out. Is it very similar to the last one? Beyond honor to mod for you, Lana. Woo! I'm telling you right now, if I was Karen Reed's defense team, call me crazy, but I would be calling me up right now and I'd be saying, send me that shit right now because we need to look at this. Matt McCabe, we can prove Matt McCabe had her phone. Jen did not. And we can prove that it happened at 2 critical points, which was the house long to die at the 2 o'clock hour and at the 6:22, both of them. He did both of them, you guys. He did both of them from her phone, which is pre-knowledge. Then why are you here? Why are you here then? God, you know nothing. You know what bugs me? You know what one of my pet peeves is? When somebody says, a word and then puts a space bar and then puts an exclamation point. That's one of my biggest pet peeves. Like, I cannot stand that punctuation. I just can't stand it. That's what, like the comment. I can't even see past the word, space bar, exclamation point. Like, God, that's just one of the things I just can't. God, if you're gonna troll me, do better. Be better. You can't fuck with the data. There is no conspiracy. Oh my God, what? Conspiracy. Wake up about what? There's 3 cases here. Love you two, bouncing ideas off of each other. Dude, I'm telling you, you want to know what she made a great point, Andrea did? Was if you're the Commonwealth, maybe you would welcome saying FBI because they'd be looking into Karen Reed, you know? And that's when you just realize, like anybody, anything that comes to you, how can you spin it? Or because that's what arguing and debating is all about, is just showing that's what you would think, because you have a jury that's supposed to say, well, I can't decide, and that's my job, as I would think as an attorney, is if I can get that person to say, I don't know, God, I don't know, it could be this, it could be that, well, then that's reasonable doubt. Check it off and move on. And, you know, how anybody can say Karen Reed hit John O'Keefe beyond a reasonable doubt, I think that's ridiculous. How anybody could say, this is based on the rules, you know, the law, like what we're supposed to be looking at. How anybody could say that Richard Allen is guilty beyond a reasonable doubt. There's nothing tying him to the scene, nothing tying him to the girls. He lives in Delphi right there. He goes out to the trails. He came forward. He turned over his phone at the time. Like, he clearly wasn't trying to hide anything if he's turning it over thinking that you guys are going to be doing such a great job investigating, you know. And in 2017, I'm sorry that we still had all those type of resources to sit here and say that, you know, they sent him home. They said, we'll call you. He went to the police department. Crazy. Oh, there you go. Thank you. Juror questionnaires are a joke. I think that they were a joke the first time. I think that the trial's a joke. I'm actually shocked. I'm shocked that Alan Jackson and Yannetti were telling Karen Reed that it's okay to do and be public like this. I'm sorry, but they're veterans. Libby and Abby could have taken Ari in a fight. I just can't wait for the interrogation to come out, guys. You know. I think we covered a lot. Yeah, there are new docs there. God damn. How you could ever get yourself in this fucking mess. Like, can you imagine what Karen Reed and Yannetti have texted about? God, I mean, what the? We got old Betty. She's printed out right now. The Commonwealth seeks all text, emails, or written communications between the defendant, Karen Reed, and attorney David Yannetti. Restricted to those communications that occur between January 29, 2022 and February 2nd, 2022. the privilege holder, Karen Reed, has waived her attorney-client privilege with attorney Yannetti relative to any statements about her collision with John O'Keefe during the time of January 29, 2022 through February 2nd, 2022. The defendant voluntarily and intentionally disclosed the existence of these communications and her initial thoughts about her culpability for causing the death of John O'Keefe during various public. Do you understand? I think Karen Reed just walked herself. I thought it even before this. I thought she walked herself into testifying. And she's going to have to say, listen, I didn't kill John, and I needed to tell everybody that I didn't kill John because I'm damned if I don't, you know. She's going to have to testify. That's what I think. And if I was her attorney, I'd be saying, no, you're not, because we have every appeal imaginable. You're going to shut the fuck up. That's what's going to happen. Bella, how hard is it to shut me up?
Just don't. If you want to shut Lana up, tell her to keep talking.
There you go.
She'll just do the opposite.
There you go. Pursuant to search warrant, the Commonwealth received the contents of the defendant's cell phone because of an observed client-attorney communication. The phone data was provided with the assent of the defendant to the Attorney General's office, and the court-ordered taint team protocol was implemented. The Commonwealth received the defendant's phone data with any privileged communications, given the defendant's public waiver of the attorney-client privilege as it pertains to the defendant's conversations with Attorney Yannetti on January 29, 2022, and the following 3 days. The Commonwealth is entitled to the communications between the defendant and Attorney Yannetti for this waived narrow period of time. Well, at least that's only between a couple days. That means Yannetti is a witness. The communications confirmed by the defendant to exist are no longer privileged nor confidential because the defendant chose to widely and publicly disseminate them. So who did she give them to? You guys, okay, so this is how client-attorney privilege works. Everything is client-attorney privilege until you tell somebody about what you and your attorney talked about. Okay? Then that doesn't make it client-attorney privilege anymore. All right? So, for example, let's say that I was like, oh my God, Karen, I want to sit down with your attorneys and I want to go through everything that I found with my research. Okay? Her attorneys, along with Karen, would sit there and listen to everything I had to say, not giving me any information. They would be taking all of my information. Then they would be stepping outside and having conversations between them outside of the presence of me, because anything that they would talk about in front of me is not client-attorney privilege because I'm there. Okay? If Karen Reed would start to talk in the time that I was there showing her all my research, Jackson or Yannetti or Little or somebody would say, Karen, shh, don't say anything. Because do not speak of anything that would be client-attorney privilege, anything that we've ever talked about before. You would be opening that up to somebody else, and therefore it's not client-attorney privilege anymore. Okay? Because if I went and said, oh, Karen told me what her and her attorneys, it's not privilege. But what you do is that, you get that? But what you do is, if you want to take in information, you bring in the person, you sit them down, and then let them tell you everything that they want to tell you about whatever they've uncovered. Here's everything. This is all my research, blah, blah, blah. And then you ask that person any questions, but you don't sit there and say and talk about in front of your, with your attorney in front of me, anything. You don't discuss anything. I have not watched the 4 episodes. Why would she share anything with anyone that would turn on her? Apparently some will do anything for $1. No, I just don't think that you realize what you're doing when you say things. Oh God. Look I got you to change the way you write. Oh, all the way up until one of them. The wake up. Oh, you couldn't break your prom. Oh. Man, you were so close to getting it right on all of those. Oh, good try. Is no longer privileged when spoke out loud in the presence of another or shared. Yeah. Hey, Murky, you can unblock that later. I just really want to look at it. All right, I'm tired. I'm gonna call it a night. Oh, wait. No. I have to show one clip here. Ready? My last clip. Oopsies. Okay. Okay. So we'll go out like this. Next up, how about Rough Riders rule? You guys have seen this one, right?
This is a ruling with Mr. Carney, so I'm asking that Mr. Carney and his attorney be at the table. I'm not sure.
I would have used the cuss version. Break it up, dismantle it. What? Look at this shit. This is fucking tits. Ah!
From meeting notes, calendar invites, texts, videos.
Here she comes.
First, this is a ruling with Mr. Carney, so
Look at Karen.
I'm asking that Mr. Carney and his attorney be at the table. I'm not sure.
How fucking tits. All right, guys. I mean, it's almost good as Truly's for the win, right? Almost. Truly's for the win. All right, guys. Peace out. Much love. Thank you so much, moderators. You guys the best. Keyboard crime fighters. Woo! Lana and Andrea is the power brains duo that these. Thank you so much. Cheers to Stevie. Go get laid.